This kind of leave to move a motion, with leave of the court at 2 on Tuesday, may it be listed. Extremely urgent one. Excise department intercepted my truckload of jaggery. Although the such interception has been done under the Molasses Act. It was sent for test and found to be a jaggery. Still, the vehicle is not being released. Report is with us, but it's a part of the petition. But I am praying this. My truck, along with the materials, are lying on the roadside. The excise department is not releasing it. But I am praying it a Tuesday. I am with leave. I am filing so that it will be listed on Tuesday. Urgent motion. I shall serve notice. Although I prayed for dispensation, but I shall serve notice.
Tuesday 2 p.m.
এটাকে লিভ দিয়ে দিন একটু। হ্যাঁ 25।
Okay, leave granted to file and be listed on Tuesday under the heading unlisted urgent motion.
Great.
Lord, one similar matter, Maharaj Dispositum 14/11/2025 regarding the blocking of Bichalan case. I am praying same matter is pending, Lord. Let it be listed on 25 as to be mentioned. It can be, I shall inform to the other side, Father.
When?
On 25 as to be mentioned, Mother. Mine has already passed order on 14th.
25?
Yes.
Okay, keep out on 25 as to be mentioned. Inform the other side.
Yes, I shall. Today I shall.
On to move a matter, anytime convenient to your lordship, it concerns the fate of an advocate who is yet to pass the All India Bar Examination, AIBE. She has passed in 2024. During the interregnum, there was one examination which was held where her name and everything was in order, father's name, date of birth, everything, without the enrollment thumb from West Bengal Bar Council. Subsequently, she
applied before the West Bengal Bar Council
for getting herself registered as an advocate. Now she has got her registration. Now, in that examination, she, for some reasons, remained unsuccessful in the first AIBE examination. Upon her passing, thereafter, there is a subsequent examination which is scheduled on 30th. Last
30th of this month.
No, November. AIBE. The 20th examination. 19th, she remained unsuccessful. She has filled up the forms. She has paid the fees. Beneath her, the photograph, she has signed as her name. Unfortunately, the admit card which has been issued by the authority in Bar Council, All India Bar Council, that admit card shows her name to be a different name. She has, and unfortunately, the name matches with the Assistant Secretary of West Bengal Bar Council here. Unfortunately, be that as it may, I had enclosed the Bar Council certificate evincing my registration with the signature of the secretary. For some undisclosed reasons, the name needs to be changed, and the examination is on 30th. I shall effect service, but any time convenient, it concerns the faith. It's not a professional. No. I'm seeking your lordship, please. If your lordship grants me today, I can try to move it today upon an email service on them, because I've been writing to them every day. In fact,
okay, you filed today. List on Tuesday. Will be listed on Tuesday.
Fairly at the top.
Yes, unlisted motion at the top.
Great.
Leave is granted to file today and be listed on Tuesday under the list under the heading unlisted motion at the top.
Great.
Lord, may I have your lordship's kind leave to mention a very urgent matter, appearing as 111 of your lordship's today's list. The difficulty is, the private respondent initially was creating a problem in installation of a meter. That's why it came up before this honorable court. This honorable court directed that inspection may be done by CSC, whether there is any problem on our file and report. Now, the report is there. There is no difficulty from the inspection. It was filed. Only an order is required so that the CSC goes and installs it. I do not have.
Appearing for the CSC.
For the CSC.
It was already filed.
Yes. They had appeared also. Inspection carried out. Report also is ready.
Why not order was passed?
The order was not thereafter. The matter was never taken up. I am without electricity. Your lordship would kindly,
accommodate, my lord, any day, my lord, subject to your lordship's convenience.
Wednesday रखो उसको, Wednesday,
Deeply obliged, my lord,
urgent motion.
deeply obliged.
Have your lordship, compelling circumstances, my lord, may I have your lordship leave, my lord, to prefer the three times. My lord, this refers to the fate of a old lady, my lord. She is a senior citizen, she is a widow lady, my lord. She has those several authorities, my lord, for her protection in her own home, in her own premises. But unfortunately, my lord, her own children have been depriving her of her own home, and she's been thrown out of her own home, and she is not having any shelter, my lord.
Which authority you have approached?
My lord, we initially had a status quo, my lord, from the civil court, my lord. In fact, my lord, we had approached every of the police.
Civil court status court, what has happened then? Who has filed the civil suit?
My lord,
You.
It was a civil suit, my lord. There was a status quo.
Who filed the civil suit? You filed the civil suit.
I had preferred the civil suit, my
For
lord.
what? Permanent injunction?
Title suit, my lord.
Title suit.
My lord. That we had preferred a civil suit, my lord. That there was a status quo, my lord. For the extension, my lord. In the proceeding, the next dates are given. So, my lord, the difficulty is that amidst the status quo as well, my lord, that status quo order has not been maintained, and the responding.
So if the status court is there, not maintained, go before the civil court, take the police assistance from the civil court itself.
Every necessary steps have been taken, my lord. I have done it.
Have you filed an application before the civil court for 151 for police protection?
My lord, date has been given under.
So why you taking the two recourse? Let the civil court decide whether you are if the civil court has passed an order. If the civil court passed an order and is directing the parties to discover and you are in occupation of the premises in question and other parties disturbing your possession, you take the recourse of 151.
The difficulty is that she is the respondents who are disturbing me, they are my own children. The son.
Correct. But
They have thrown me out of their position.
But you have initiated a civil suit. What can be done now in the writ court? Once you got the status quo order, how the writ court can interfere in that?
We have made several recommendations.
Okay, you filing a regular course, no urgency. I didn't.
My lord, may I have your lordship leave to mention, I mean, the leave to move an urgent motion, my lord. My lord, the district Midnapur East, my lord, the district election officer requisitions the cooperative bank employee to join in the poll duty of the forthcoming upcoming West Bengal elections, my lord. My lord, the cooperative bank's employees are not the government employee. They are not amenable to 159 of the people, and that's we are guided and supported by an order of this Honorable High Court. And but despite of knowledge, full knowledge of the election authority, my lord, they started requisition. And today is the date.
When you have to join?
Lord,
Got the notice when you have to join the duty?
today. And the bank authority, what happened? Bank authority, despite of notice, they received the notice on September. And the last date of finalization of the list was October. And today is the date for verification. Despite full knowledge of the bank authority, they did not inform the employee.
Verification, name verification.
Name verification, and they will enlist the duty officers and etc. But we are protected by the.
Correct. So today there is a verification, then the final list will be published.
Milord, unless we are protected hand before, Milord, once our name is enlisted, Milord, we are duty bound. We have to attend.
Correct.
But it is unlawful as per the High Court's order.
Submitted the representation to the concerned election commission.
Milord, there is no time. Today is the date. Unless I have been granted.
When you got the information?
Milord, just day before yesterday.
Could have been tomorrow. What you have done?
Milord, I have prepared. Milord, the entire 150 employees have came before me, and I have drafted.
150.
Yes, Milord. All. It is on total.
All the cooperative bank.
All competent, and they have requisitions to all 196. The
cooperative bank staffs.
Yes. Malad, a leave may be granted so that I can move it before your lordship on Monday, Malad, upon notice. A leave may be granted.
Monday, I already fixed.
Malad, it is extremely urgent, Malad.
Okay. Leave is granted to file the writ and to mention as unlisted as urgent motion on 24.
I'm taking
24.
leave to move this matter, the extremely urgent, which is I'm taking also leave to move it at any time.
What is the urgency?
The e-auction was held August 25.
What?
E-auction
Ah,
was held August 25.
ah,
I was declared the highest bidder,
ah,
but they have not yet issued the work order.
hmm,
But I made representation.
ah.
But day before yesterday, I have come to know from the office that they are going to cancel the entire process, so that if
So,
the
but not yet cancelled. Let the cancel, then you
They-
come.
at
What?
any time, my lord.
No, no,
The-
no, no. Yes.
Next week, my lord, any day, my lord.
You file in the routine manner. Yes.
I have a lordship leave to mention this matter. I have mentioned this matter on yesterday, your lordship may remember. This matter, I am the petitioner and I am the charitable and religious trust, your lordship.
Hmm.
And they have a program on this Sunday, your lordship.
Not listed
And it was,
today?
no, your lordship, it was
Please.
directed. It
Why
was
it is not
directed to
listed?
listed on to today.
Once I am giving the specific day, why the matter is not been listed?
Your lordship, kindly listed into the supplementary list, your lordship,
It is not
because
listed. Show me the requisition. When you have requisition, send the requisition. Or call the office.
yesterday, yesterday I have mentioned, yesterday.
Yesterday mentioned there is a program of the child welfare and all these things. Okay, let me see.
Quickly apply.
Lordship, may I permit to leave?
Your lordship's kindly, but I seek to file this requisition.
Huh?
I seek to file this requisition with your lordship's kindly on what has happened when the Maintenance Tribunal under the Maintenance Act of 2007 has passed an order evicting my lord, the son and the daughter-in-law.
Correct.
Now, the order was passed on 4th of September, my lord. The son was suffering from cancer and he has passed away in the meantime. Today, the petitioner, the daughter-in-law, is before your lordship.
Who is the petitioner?
The daughter-in-law,
Ah,
along with his minor son,
Ah.
with a minor son.
Ah.
But they have no place of residence, my lord,
Ah.
apart from this residence. And there is a parallel proceedings under the Domestic Violence Act pending.
Hmm.
But there is an honorable
in
judgment.
the
of the
domestic
honorable-
violence, there is an interim order.
This is a final order.
No, in the domestic violence.
No, no order.
Ah.
But when the honorable apex court says when a parallel proceedings under the domestic protection act is there,
Ah.
and there is a concept of a shared household, the daughter-in-law or his son cannot be evicted.
Hmm.
But the difficulty is, my lord, the order was passed on 4th of September.
Hmm.
But the Monday, the eviction proceedings would be, my lord, to be initiated against me, my lord. If this,
So what you have done for the last so many, why is it 19th hours you have
my
waited?
husband passed away on 19th of September, my lord. She's a
19th of September, we are in
she's a
December,
destitute lady, my lord.
November.
but very
40 days is over by the
very
October.
poor lady, my lord. His husband was a taxi driver.
So what?
No income of, no means of sustenance, my lord.
Huh.
Kindly grants leave, my lord, to file today. I'll try to move.
Sir, the order was passed in September and you are sorry.
Well,
Yes.
the eviction is the my
Lordship,
petition becomes
File
inside.
it. If it is,
Lordship, I'm paying for leave in this matter. Lordship, I'm paying for leave in this matter. Lordship, urgency is that Lord, I'm paying for held the really, Lordship.
Huh?
I'm praying this matter, Lordship. The urgency is that, Lordship, I'm praying. I'm held meeting really in the month of December, first week, Lordship. But the concerned department have refused me. There is no permission need to permit without High Court order. We need to give me any
What?
permission
what
for
purpose?
rally, Lordship.
Huh?
For rally demonstration, Lordship.
For rally. Where you want to conduct?
Shahid Minar, Lordship.
Huh?
Shahid Minar.
Who are you?
I'm the workers' union, Lordship.
Workers Union. What is your give answer?
Grievance, Lordship, there is a lot of pensioning and Lordship, illegal activities, Lordship.
When you issued the notice for the rally to the authority,
They have refused in the month of April, Lordship.
then April refused,
Lordship.
now we are at November.
No, Lordship, this demonstration will be held on month of December first week, Lordship. Next
December 1st week, when you issued the notice for you will hold the rally.
April 28th, Lordship.
April, when it was rejected.
28th April, Lordship.
Then you file a separate. April it was rejected, now you are coming on November. Have you informed the December date? Ask for the permission in the December.
Lordship, through email, Lordship.
Where is that?
That I'll print out, Lordship.
Without the writ petition, without including writ petition, filing a writ petition.
No, Lordship, that email I will be annexed this petition, Lordship.
How you will annex? Already you filed the writ petition.
I'm not fine, I'm praying for leave, Lordship.
No, sorry. Call the next. It has not yet come from the department.
Lordship, kindly direct it to appear into the supplementary list. Otherwise,
If
it will
is
become
re-
infractional,
no,
your
if
Lordship.
it is received, it will be listed. You talk to the department, you go to
Deeply
the
obliged,
department.
deeply
If it is come, then it will be
Deeply
listed. No
obliged.
problem. Yes, call the list.
Lord, I am for the petitioner in this matter.
I beg to appear for the my lord, respondent number 1, lordship.
Now, my lord, this writ petition, my lord, was dismissed for default on 8th of May 2025. The reason being is that, my lord, I could not appear, my lord, owing to my illness, my lord. I have to leave the court when the matter was called on, my lord. Now, in this writ petition, my lord, an innocuous prayer is being made, my lord, that my complaint under section 18, read with section 20 of the Right to Information Act, presented by the petitioner on 13th October 2023, be disposed of within a time frame as may be fixed by your lordship, my lord. Now, that's an innocuous prayer, my lord, I made in the writ.
Of course, sir, but you are not appeared before the court. What the court will do?
My lord, on 8 May 2025, my lord, I have to leave them. I have stated in paragraph number 3, my lord, of my restoration application.
Yes.
Lord, I beg to appear on behalf of the my lord, respondent number 1, the West Bengal Information Commission. So far as the restoration is concerned, my lord, this within time I leave it to your lordship, my lord.
It's
I don't
within
want to
time,
make
my
any
lord,
comment.
right on 20th May.
The petitioner has filed the present present application.
Issue copy.
Can
I have already served this affidavit of service.
praying for
Nana,
order
already copy has been served.
8th May 2022.
Writ petition is also served to you.
When
You are for?
this court has
Commissioner.
dismissed
That has been served upon you.
for non. Counsel for the petitioner submitted on the date fixed. The petitioner was date fixed due to sudden ill health of the petitioner, the petitioner had left court premises, due to which the petitioner could not appear before this court. Had the learned counsel for the parties produced the application, this court find that sufficient reason has been shown for non-appearance of the petitioner before this court on 8th of May 2025. Accordingly, order dated 8th May 2025 is recalled. WPA number 3850/2024 is restored. Original file. Can number 74.
Will it be my lord pleasure, my lord, to dispose of the writ petition itself, my lord, as an innocuous prayer is there, my lord? Only for dispose.
Sir, let this matter come under the motion, my lord, and let a copy of the writ petition be served upon me afresh. Since my lord, it was disposed of, my lord, the writ petition, this copy is not with me right at this moment. If my provide me a
Let the matter appear on 26th. Under the new motion.
Grateful, deeply.
let a copy of the writ petition be filed.
Yes, next.
Grateful, lord.
Deeply. Lord, may I file the affidavit of service?
Yes, affidavit be kept in the record.
Number 20.
Grateful, lordship.
You there.
I am praying for not today.
Huh? Who is for the state? Yes.
Sir, I am praying for not today.
No. Have you gone through the last order?
The old matter.
Either you ready, I will dispose of on merit. Either you argue or I will dispose of on merit. It is your choice. 3 days before this matter has been already informed in the cause list, the criminal matter will be taken first on Friday. And when the earlier occasion the matter was taken, you had taken the time, all of a sudden the matter was listed, that's why you are not ready. And this court has fixed today. Yes, it is your choice, tell me.
May I, Your Lordship? Since Your Lordship, the petition is Your Lordship, the NOC brief. I got the brief yesterday.
Maybe.
Just, the
Maybe.
advocate and record
Is there any interim order?
so far, Your Lordship, I have been instructed that there is no such interim order.
In view of this, director to supply the photocopies of the prosecution window, copy of the examination. So I am recalling the order of suspension. I will get on the matter. I will be recalling the order of suspension, directing the police authority to arrest you and produce before the Leonard court. Serve the sentence.
May I, Your Lordship, I'm seeking for a short
No.
passover, Your Lordship, since
Yes, what is the
I don't have the
My lord, it's a old matter, my lord. There is no copy, my lord.
I will send your name to the state that you are not a proper person to be continue with
My
it.
lord, it's a old matter. My lord.
Maybe old matter. Why you accepted the matter?
My lord, earlier occasion, my lord, visiting your lordship, my lord, there is no copy, my lord, in the PP office, my lord. The old matter, my lord, is in the year of 1993. Kindly, my lord, kindly, my lord.
Sorry, that's why I picked the matter especially on Friday.
I also, my lord,
This court
asked
find
my
that
learned
since
friend, my lord, to serve a copy, my lord.
1993 matter is pending before the court.
My lord, I also,
And you persons are enjoying the interim order and
my lord,
taking the
earlier occasion,
benefit
my lord,
of the.
teaching before your lordship, my lord, and requested my learned friend, my lord, to serve a copy, my lord.
No. I will not adjourn the matter. Both are ready. Then I am fixing as a CAV. I will pass a prepared order. I am giving 5 minutes to decide.
My lord, we are ready to, my lord, do the
Yes,
matter. My lord,
do.
but we don't have, my lord, the copy. Now, until and unless, my lord, we don't have the copy, my lord,
Record an
the
order.
matter, my lord, is
The
1993.
matter was listed on 7/11/2025, but none appears on behalf of either of the parties. Accordingly, for the interest of justice, the case was adjourned. In the order dated 7/11/2025, it was categorically mentioned that on the date fixed, if the matter is not been, if none represented for the petition, appropriate order will pass. Today, when the matter is called, the learned counsel for the petitioner as well as the learned counsel for the state praying for time. This court find that the matter is the matter is filed in the year 1993 and have also obtained the order of suspension of sentence and the petitioner is enjoying the interim order. Accordingly, this court find that the petitioner is not interested to proceed with the matter. That court find that the petitioner is only to drag the matter. Accordingly, the matter be treated as hearing concluded. CAV. Next. None appears on behalf of either of the parties. No accommodation is sought for. This court find that the petitioner has filed the present revisional application challenging the order number 32 dated 31st of July 1993 passed by the London Special Judge Court cum Additional District and Session Judge Bardwan wherein the learned judge here has held that the accused Nita Chandra Sarkar was the below 16 years on the date of incident, and as such the accused is to be tried under the Juvenile Justice Act. As none appears on behalf of either of the parties, accordingly, the learned district special judge cum additional district and session judge Bardhaman is directed to submit the report with regard to the status of the case with being sessions case number 25/1991, State versus Nita Sarkar alias Suko and others, and if the matter is dealt by the concerned juvenile board, such report will also be placed before this court. Let the report be filed by 3rd of December 2025. Release the matter on 5th of December 2025 under the same heading at the top. Next.
Milord, in item number 5, Milord, the challenging the order of acquittal, Milord, under 326 and so Milord 300-34, I prepared a revisional application against 5 persons.
Yes.
Milord, subsequently, Milord, over the same order of Milord acquittal, the state had also filed an appeal. Milord, that is Milord government appeal. So, Milord, it should be merged with the government appeal.
What is the government appeal number?
Milord, government appeal number is Milord, I am giving you.
Direct both the revision can be. That is appeal or revision?
Milord, appeal, government
Appeal might not be here.
not here, Milord.
Then
And Milord, the appeal would be Milord heard by a division bench because it is 302.
So what is the status of the appeal?
Milord,
Okay, whatever the appeal. What is the status of the appeal?
appeal, Milord, admitted.
Give the number. Give
Milord,
the number.
Milord,
I will
Milord,
call the
just-
record. As per your submission, I will call the record.
Milord,
Report.
Milord, make it not.
No, you give. Otherwise, I will dispose of hearing. No.
Criminal.
Sorry.
Milord,
Not
short,
today, not tomorrow.
no, Milord, short Passover. Short,
Passover, give-
my Lord, I'll give the number, Milord.
I will call at 11:30.
My Lord.
Yes, call the matter.
My lord, I am for the petitioner.
I am for the
My lord,
acquitted respondent.
today my difficulty is that my advocate on record has fallen ill.
Be difficulty. You get ready. Otherwise, I will dispose of the matter on merit.
My lord, can you record my submission and dispose of that advocate on record is unwell? As a senior advocate, I cannot appear without an advocate on record.
No
My
problem.
lord, there is a report called for on behalf of the state. My lord, the report has come. My lord, the petitioner had expired on 11th of September 2024. If you give
Who expired?
The petitioner.
the petitioner had
We have filed an application for substitution that is pending.
that application.
And my lord, the
The application for where is the application?
application is on record.
The application number.
My lord, application number to copy the আমার তো বাড়িতে brief ই নেই ও তো advocate on record অসুস্থ
Cran 1 of 24.
CRAN 1 of 24.
Who is the petitioner before this court?
I am the petitioner.
Who is?
The petitioner is the wife of the person who was shot dead by the police.
So what application is this?
This is an application revision against an order of acquittal.
Against
So,
an acquittal.
Against an acquittal. She has expired, so her daughter has filed an application for substitution. In page, I have a scanned copy of that application. So from that, I can say, my lord, page 11 is the death certificate. Police, I believe, also has submitted a report. My lord, kindly allows the substitution, and also, my lord, kindly sees the order dated 28/7/22.
28/7/20.
Justice Ghosh gave a direction upon the department to prepare a compilation of the prosecution witnesses, defense witnesses, and the exhibits. And there was a direction to serve copy upon the learned advocates. My lord, the learned advocate kindly sees the name at the top, Mr. Subhashish Rai. At that point of time, I was assisting him. The copy was served upon him. He passed away. So I do not have a copy of this. So a copy may be served upon me so that I can prepare and assist this court. And in the meantime, my lord, kindly allow the substitution application.
Hey, whether the copies are there in the record? Copies.
I believe the rest of the parties' copies have been served.
No, my lord,
Not having?
no, the state has also not received. my lord. I only have the copy.
তখন রিসিভ করেছিল তখন তো অন্য একজন ছিল ছিল তো 6 মাস থাকলাম 6 মাস থাকলাম হ্যাঁ 24-এ এসেছি হ্যাঁ তোমার কাছে আছে তো বড় কপি
Then is there. So you are not received copy.
No, my lord, we have received the copy, but the earlier advocate.
Who are you?
মানে আমি দি অ্যাকিউটেড রেসপন্ডেন্ট
The acquitted. You have a copy to the
Yes, I can make a photocopy of it if my learned friend.
copy to the petitioner.
We'll do that, my lord. I'll also take a copy from my lord.
And my lord, kindly allow the substitution application. I do not believe that my learned friends will have an objection to that.
all the matters may be taken up together my lord because my instruction is my lord there are 3 daughters 1 son one has come only
Have you received the copy? Can?
yes my lord I have
Have
received
you filed the affidavit?
no my lord
You will not file.
no not
So what is your objection?
no one only objection is my lord there are 4 one has come and my lord at the relevant point of time the alleged incident is of my lord 31st of January 1995 and the lady my lord affirming affidavit she has stated that her age is 33 my lord so at that point of time she was 3 years old
Whether she
this is my lord lordship knows much better than me my lord this is a revision against acquittal this is a revision against acquittal my lord under section 403 my lord even if your lordship takes a different view or the second view your lordship cannot convict the accused your lordship have to send it for retrial my lord it's a case of 1995 my lord most of the witnesses died 2 of the accused died IO died
Against acquittal.
Appeal against acquittal.
The revision.
So at that point of time, there was no power of
at that
appeal.
point of-
372, I mean,
Which year? 2002.
yes my lord incident of my lord 31st January 1995 my lord nobody left my lord most of them are not here
Your accused persons are available.
yes.
one died and 3 my lord one paralyzed another is bedridden another is my lord suffering from my lord
What is the sentence?
no my
No,
lord,
acquittal.
it's a acquittal my
What is the case?
302.
lord.
case of the
Well, Is a
case
well
of
reasoned judgment well reasoned judgment my lord Everything is-
That is
But,
subject
my
to
lord,
your lordship's.
my lord, whether my lordship will open that my lord I'll place judgment my lord
State has not preferred an appeal.
no nothing
No,
State
State
has
has
not
no. Because these were police officers, instruments of the state.
Okay. So how soon you
just now I'm giving let him get it just my lord.
the Leonard Counsel appearing for the opposite party number? You are appearing for the opposite party number
2 my lord I am for 2
2, 4, and 5.
4 my learned brother is appearing and 5 learned
You
friend
are
is
appearing for the 2.
I'm for the
Leonard Counsel appearing for the respondent number 2. Opposite party number 2
এক তারিখ
has served
এক তারিখ
the copy of
তুমি দেখে নাও
হ্যাঁ তো এই সপ্তাহটা আজকে শুক্রবার আছে দিয়ে দে 1 তারিখ এনি ডে আফটার ফার্স্ট 1 তারিখ
has served the compilation of the prosecution witness, compilation of the statement of the prosecution witness, defense witness, and the exhibits to the Leonard Counsel for the petitioner. The petitioner has filed an application being CRAN 1 of 2024 for substitution of the petitioner. This court found that this application be heard along on the next date fixed. Let the matter appear on. When you all persons will be available as per your convenient time.
My lord,
fixing the date,
any day after first, because we'll go
1st of
through these
December.
documents, any day after first.
Let the matter appear on 5th of
Fifth
December
তোমার problem আছে না?
at the top.
Fifth problem আছে বললে তো?
5th of December under the same heading. Not up, at the same.
দুটোর সময় বলছি।
Yes, next.
Grateful, my lord.
My lord, let it retain its position, my lord.
Yes.
Yes, yes.
এটা নিয়ে না just করে নেবে তো?
হ্যাঁ, কপি দেখুন। আমি জেরক্স করে দিয়ে দেবো। Grateful, my lord.
বিপ্লব।
Lord, here, the state has come up, my lord, against the discharge order passed by the special court. My lord,
Here discharge was made 2003.
my lord, 2003.
There is any interim order? Stay of the discharge order?
My lord, probably there is no, my lord,
What
there
do
is
you
a, my lord, we had filed a section 5 also in this case. My lord, probably that has been allowed. My lord, tally sees. And my lord, the impugned order, my lord, is absolutely illegal, my lord, on the ground. My lord, this matter had gone up to, my lord, this, I'll just state the, my lord, the facts of the case.
What is the
Facts of the case, my lord.
no? What is the section?
My lord, sections. My lord, sections relates to, my lord, I'll just tell you, Lordship, 420, 420, 468, 467, 471 IPC, my lord. And 120B. My lord, against certain employees of a cooperative bank. Now, my lord, this matter came up before the special court, and special court, considering that that court does not have the jurisdiction, my lord, had discharged them. Now, my lord, humble prayer before your lordship is that, my lord, the case was not under 409. So definitely, my lord, the special court did not have the jurisdiction. But in that even, my lord, that the entire matter should have been taken by the other court, because these things, whether they have actually committed the offense or not, my lord, that has not been considered at all. Considering that they are not the public servant, considering that that special court does not have, my lord, kindly comes to the impugned order.
First, you show whether the section 5 is allowed or not.
My lord, it was allowed.
By which order?
My lord, actually, we do not have that order also. If my lord, the records.
Records also does not speak anything. That the matter is
If my lord, if it's not showing, my lord, my lord has got the section 5 application in your lordship's record.
The old matter, my lord.
Very old matter.
Website also there is.
That's why on the basis of the old matter, you persons are not doing the matter 1993, 2003. Someday it has to be disposed of.
My lord.
Then?
My lord kindly disposes of the section 5 application.
Where is the section 5? Section 5 is not here.
Section 5 application
pending है. बात कम किया करो. Other records are there. Where is the CRAN?
My lord, CRAN is 426 of 2003. Well, there was a delay of 76 days that has been explained.
426.
Yes, my lord. 426. Yes, my lord.
In your department director to provide the copy of the original application along with the annexure if there be any photocopy of the same to Miss Faria Hussain, an advocate by June.
Section 5.
Section 5 application नहीं है. नहीं है.
76.
Yes. How many days?
My lord, 76, my lord. And my lord, the explanation is given in paragraph 3, my lord.
Section 5, my lord, I am not opposing.
You note all of no. 2003, today the section 5 is going to be heard.
My lord, I am led by Mr. Bas.
You can allow the section 5 application and fix the other matter for me.
For hearing.
In the month of December or January. January.
State has, not January, December I am fixing. The state has preferred an the present revisional application against the order. passed by
Section 5 একটা application করেছে ওরা সেটা বলবে তো।
by the learned judge, First Special Court, Alipur, dated 27th of August 2002, in special case number 24 of 1995, arising out of which police station?
My lord,
Karya.
Karaya PS man.
Karaya, K-A-R-A-Y, Karaya police station.
27 dated to
27
2nd of December 1990.
92 under section 420/468/467/471/120-B of the Indian Penal Code. The state has also filed an application being grant 426 of 2023, praying for
2003 থেকে
condoning the delay of
আমাদের নোটিশ হয়েছে।
how many days? You are not mentioning here.
My lord, 76. My lord, I've mentioned in paragraph 4, my lord.
76 days in the revision application. Full stop. Learned counsel for the respondent has not raised an objection for condoning the delay of 76 days. Accordingly, 76 days for preparing the revision application against the order dated 27th August 2002, passed by the learned First Special Court, Alipur,
আমরা তো খালি পর অভয় পত্র লাভ
is condoned. Is condoned. CRAN number so and so displayed.
Lord, pursuant to this lordship, my lord, this honorable court, my lord, we were asked to serve the copy upon the opposite. My lord, we had served, but my lord, most of the, my lord, has returned back, the service has returned back saying that they have left that place.
How many accused persons?
My lord, there are total 4. 3 has, my lord, my learned friend is appearing for one of them, and 3, my lord, has returned.
Respondent numbers 2 and 3. My lord, 3 has died.
3 died.
My lord.
So that is why, my lord, but the envelopes have come back
You
saying
are
that
appearing 1 and 2.
I'm for 2 and 3, my lord.
2 and 3.
2 and 3.
3 has died.
3 died.
There are total 4 of
We are
them.
appearing for 2 on
2 and 4.
Only 2.
only
Now,
2.
3 days, only 2 now.
Oh,
So what
3 is
about the 1 and 4?
Four, I
What
know.
about the 1 and 4?
My lord, the letters have come back stating that they have left that place.
So you are the police personals. You are the state authority, and your case is there. You have to make endeavor to service of
My lord, we'll
someone.
try again on
And
the
you are
next
sent
day.
by the post
Yes, my lord.
through your agency. You served it.
My lord, we'll try our level.
And they will locate the persons. You are appearing for the state. Learned counsel for the opposite party number 2 submits that, though he was appearing for the opposite party number 2 and 3, but the opposite party number 3 passed away. Accordingly, counsel for the state submits that she will take appropriate steps. The counsel for the state has filed affidavit of service showing that the notice could not be served upon the opposite party number 1 and 4. And the notice has been written unserved with the endorsement left, addressee left. Here, this court finds that this is the state case initiated by the police of Karaya police station. Accordingly, the state is directed to serve notice upon the opposite party number 1 and 4 through the concerned police station, and to file affidavit of service on the next date fixed. List the matter on 12th December.
12th December.
12th December, Mr. Bose.
Grateful, your lordship.
Next.
Your Lordship, item number 8 and 9 are together. Your Lordship, the conducting advocate's wife is admitted today in the hospital, Your Lordship. On that ground, I'm praying for a 1 week's adjournment, Your Lordship. Unable to come today, Your Lordship.
Outset, my lord, we are praying for, my lord, direction for filing affidavit in opposition, my lord. We want to use affidavit in opposition.
Opposition.
This is, my lord, regarding, my lord, costing of
For matter now, your 2025 you want after the,
Paris, my lord, first time it is appearing, my lord.
huh?
Paris, my lord, first time.
What you are telling, sir? First system after the matter is appearing since there. 2004 it had appeared. Since 2004 it is appearing continuously.
My lord, kindly allow me 2 weeks time. My lord,
What opposition?
they have.
What is the revisional? What is the revision application, sir? What is the revisional application?
Complaint being case number 347 of 2004 under section 63 of the Standard Weight and Measures Enforcement Act, under section 51 of Standards Weight and
What is the revision? What order you challenge? 482. You challenge the total complaint.
It's a complaint case, Your Lordship. Challenge the complaint, yes, Your Lordship.
Challenge the complaint case. And 2004 it was filed. Who is appearing for the complainant? Bharat Petroleum. Bharat Corporation.
We are Bharat, for the petitioners, Your Lordship, Bharat.
Sandeep Mehta, Inspector Legal Metrology.
Yes, my lord. I am for response number 2, my lord.
You have filed the who has filed the complaint?
State is there, my
Who
lord.
has filed the complaint? Legal Metrological Department.
Yes, my lord.
Where is the complaint?
Complaint, my lord, paragraph 13.
Huh? Where is the complaint?
P2. Right.
P2.
My lord, this complaint has been filed for violation of various sections of the Act, my lord.
Correct.
So-
Where is the complaint? I could not find.
Only section 33, Your Lordship.
Page 23. That is also not legible.
Not legible. 24.
Any cognizance was taken in this application, in this complaint?
My lord, in the meantime, my lord, I will take instruction. What is the matter, stage of this complaint case pending in the scale the court, my lord?
Huh?
At scale the court, it is pending, my lord. What is the position, my lord?
Issue summons.
Status.
You are appearing with the trial court. You are appearing before the trial court.
No.
No. So what has happened? Is there any interim order?
Already against the summons already you have appeared.
Maybe you are appeared. There is an interim order. If you are not appeared and there is no interim order, the warrant will be issued and the proceeding will be continued. If there is no stay of the proceeding, I don't think there is any stay. You are appearing for the what steps you are taking before the trial court?
My lord, that I will not take instruction of what is there, my lord. Perhaps, my lord, this officer has been changed, my lord. The by name Sandeep Mehta.
Maybe officer change.
Yes, my
but
lord.
the office will
My
be
lord,
there.
my lord, grant me, my lord, 2 weeks time, my lord. 2 weeks time. In the meantime, my lord, I will take the status of the
Interim order
proceedings.
So extended from where is the interim order? Stay of all the proceeding. 2004 you have taken the stay, we obtained the stay order on 25. 21 years passed and you are also sleeping over the matter.
I could already had the two matters in this matter. Already section 63 already has been passed by this honorable court.
So what has happened? This matter?
The facts and circumstances are different.
Again,
Other matters.
Other matters.
Against the BBC.
Learned counsel for the opposite party. Number 1. Press for time to take instruction. Accordingly, case is adjourned. Let the matter appear on 12th of December 2025. It is made clear that on the date fixed, no adjournment shall be granted. Come ready on that day, sir.
My lord, in the meantime, if your lordship please to, my lord, allow us to use evidence in opposition, my lord.
No,
Not necessary.
Cognizance has been challenged. What's the opposition? Your complaint is there.
Yes, ma'am.
What opposition you will file? You have to justify your complaint is in accordance with law. That's all.
Yes, ma'am. 8-9 same, my lord. Right, sir.
May it please your lordship.
Same order.
My lord, 13 persons faced a trial. Out of 13 persons, my lord,
Item number?
10
It's a revision from an order of
conviction.
conviction.
13 persons, my lord,
What is the section?
149, 1 year, 436, 7 years,
Hmm.
and 427 by 139,
Hmm.
149, 2 years.
Hmm.
These are the convictions, my lord.
Hmm.
Now, my lord, there are total 5 accused persons before your lordship, 13 faced trial, out of whom, my lord, others have been acquitted of the charges, and my
Total, as per the charge sheet, 13 accused persons.
13 accused
They
persons.
face trial.
Faced trial.
Out of 13, 8 have been acquitted, 5 have been convicted.
My lord.
And the 5 persons have made preferred an appeal before the London District Session Judge.
Yes, my lord.
That was dismissed.
No, that was, yes, that was dismissed.
Now
Against
you
that, my
prefer
lord,
the
I have
original
before your lordship.
Practically a second appeal, if your lordship.
It was revision, second appeal.
That is why a revision.
So only limited
Law point.
point is there with you.
Yes,
What are
my
the
lord.
point?
But I'll show you, lordship, my lord, the learned code below, the sessions judge, my lord, has in a criminal law, my lord, vicarious liability does not attract. The concept of vicarious.
Yes, past your appellants are petitioners are there.
One has died, my lord, to our instruction. Appellant number, petition number 4 has died. Others are at the verge of, my lord, to the abort. Now, my lord, if you lordship, my lord, I'll show you lordship the differences. But before that, my lord, only one point what struck me, the learned session judge, my lord, has observed that there is a vicarious liability. And vicarious liability.
Lower court record is not here.
But on the last occasion, my lord asked for the lower court record.
Lordship had called for.
The lower court record hai.
Emma, করবো কি
There
করে?
must be a report from the
Yeah.
department there.
Report be submitted from the department, my lord. Has to be.
रिपोर्ट भी नहीं है, फाइल नहीं भेजा था, डिपार्टमेंट ने भेजा नहीं होगा. Which court?
This is
Purulia.
Huh?
Purulia.
Purulia.
Yes, ma'am.
You have all the documents.
But I've got the, my lord,
Only the 2 copies of the
evidence, the judgments I have, my lord.
Evidence is not there.
Evidence, one copy I have, but that's marked with. Like if your lordship asks for, I can.
Okay, I'm calling for the lower court record.
Required.
So the exhibits will also be here.
This court find that for hearing of the revisal application, the revisional on the lower court trial court record is required to be produced. Accordingly, department is directed to call for the trial court record. Where is the magistrate order?
At page 40.
Just after the affidavit.
Respect of the session state number 49 of 1989.
And a running page.
9. Under section 148. Plus 149 plus 436 plus 427 plus 448 of the IPC. Which PS?
This is
Sessions Judge, Assistant Session Judge, Additional Court, Purulia.
That is correct.
Oh,
But
huh?
which PS connected with
Which
PS?
police station? Well, police station will be Halda. Well, cost title Malad would find JHALDA.
internal page 2 of the judgment by the magistrate. Second paragraph on the top. Jhalda PS.
In the judgment?
Yes,
Yes,
Malad.
Malad, page 13, Malad, of the brief. Internal page.
Yes, Jalsa.
PS Jhalda, the number is also there. FIR dated.
Being FIR number. What is the FIR number? FIR number is not there.
The FIR number is not there.
No FIR number.
That is
How the judgment is written? Jalda PS before this court on the next date fix. This is the matter on 19th December. 19th December.
19th December. Nine-
19th Friday.
But either on 19 December, I may not be here, my lord. Maybe before that or after that, my lord. Kindly. Anytime that suits your lordship, but 19th I might not be there.
Okay, 12th December. Next. Supplementary.
Supplementary. Just
2:30 Friday.
No, 19. I'm sorry. I will
19th.
Friday. 12th I will not be there. 19th. Great fit, lordship.
Supplementary at 2:30.
Well,
Yes, nobody is there. 482. None appears on behalf of either of the parties. No accommodation is sought for. This court finds that the matter is to be decided on merit according decided on merit according to CME. Next. Though none appears on behalf of either parties and no accommodation is sought for, but this court is of the view the revision application is to be heard on merit. Accordingly, the department is directed to call for the lower court record, the entire court record of sessions case number 106 of 1985 and connected PS case number 6. Harishchandrapur PS case number 6 dated 9/10th December 1985 under section 304/34 of the IPC. Before the next date fix. This is the matter on 19th. Next.
Item number 13, I appear for the petition.
To appear for the state.
These for quashing of the proceedings of GR case number 390 of 2007.
Yes.
Lord. under section 7(1), subsection A, clause 2 of the Essential Commodities Act. The allegations are, in a nutshell, allegations upon me are, I run a resort. The petitioners run a resort, hotel cum restaurant, resort. Now, the allegations on me are, I have used domestic cooking gas for commercial purpose. That is the allegations upon as per the FIR. My lord, may I kindly take my lord to the FIR?
Where is the FIR?
My lord, page number 15 onwards. My lord, complainant so and so, my lord, so and so, Anjandhar, Chandandhar. These are the petitioners, my lord. Anjandhar and Chandandhar. These two persons are the petitioner before your lordship.
That's. Another case director.
Lord, on the last occasion, there was a direction from your lordship for the trial court record. My lord, trial court
Let me
records
see,
are
let
there.
me see. The
My lord,
state
I've
is
got
there.
the case diary.
Yes, I will take the case there. Yes.
But not the allegations, my lord, has gone.
What is the ground of challenging?
My lord, ground of challenging is that I have, my lord, two licenses. One is in the name of resort, that is Nirala, and one is in the name of Anjundhar, and also another gas card on the name of Chandandhar. That means there are total, as on date, there are total 3 licenses. Now, my lord, as per the, my lord, as per the liquefied petroleum gas regulation and distribution order, my lord, I challenge the maintainability of this prosecution, my lord. Why, my lord? Because clause 13 of the said, my lord, regulation. No, it doesn't.
Yes, clause 13. Which clause?
Clause
13.
my learned friend is actually clause 13 means. Clause 13, my lord, power of entry, search and seizure. Any officer of the central or the state government not below the rank of inspector duly authorized by a general or a special order by the central government or the state government, as the case may be, or any officer of a government oil company not below the rank of sales officer authorized by the central government may, with a view of securing due compliance of this order or any made under, stop and so and so, so and so. So, my lord, the precondition, my lord, for this clause, for in making any search and seizure into the premises, not a written order from the competent authority has to be taken. My lord, that, my lord, has not been. I have not got a copy of that along with the charge sheet. My lord, whether it is there on record or, my lord, exactly the date of that order, that is important, because, my lord, that has to be taken prior to the lodging of the FIR. That is, my lord, that is what this notification says.
This is one aspect.
This is one aspect.
And
Now,
second,
my lord, second aspect is, my lord,
just a minute. Who is the complainant here?
my lord, complainant is Inspector of Police.
Is the Inspector of Police. Dilip Kumar Devnath, Inspector of Police.
Yes.
So he has conducted the raid.
He has conducted the raid.
Yes.
But my lord, I have pointed out, my lord, that written permission, my lord, has, whether it has been taken or not, my lord, that has not been mentioned, or my lord, has been annexed in the charge sheet.
Charge sheet is there.
Not charge sheet, my lord.
Charge
the
sheet is
case-
there. Then, so that is a matter of trial.
My lord,
That is a matter of trial. If it is charge sheet is not there, you are telling me
my lord,
that.
charge sheet is not there because, my lord, there was an order of stay by the coordinate bench of.
Correct.
this
That's
Honorable
why you have
Court.
taken the stay. Investigation could not be completed. So how this court can call the report during the criminal revisional application whether there is an
My lord, if my lord, may I show, my lord, a judgment also, my lord, where, my lord, where the prosecution, where the prosecution is prima facie, my lord, not as per the law, my lord.
correct.
In that
See,
case.
prosecutor prima facie is the inspector.
He is an inspector, my
Whether
lord.
there is an order or not, it has to be considered at the time if they file the charge sheet. If it is not, if the seizure was drunk on, automatically charge sheet will go.
And my lord,
This is an FIR.
my lord, after hearing me, my lord, my lord, second aspect. They say that I had three, my lord, if I get into the merits of this FIR also. If I get into the merits of this FIR also, my lord, they said that I had 4 cylinders in total. 3 of them were empty and 1 was in working condition. Now, my lord, kindly takes my lord, page 13 of my application. This,
Page 13.
yes, the part of the seizure list, my lord.
Page 13 is your application, sir. Revision application.
My lord, page 19. The internal page 13, page 19. That is
19.
19 of my application. Yes.
19.
Yes, 19. Part of the seizure list, it starts as hence I seize the articles mentioned in this one. So
19.
yes.
19 is the this is a complaint. Continuation of the complaint.
Lord, hence I seize page 19 of my application, my lord, it is the page starts with hence I seized.
No seizure here.
But then, my lord, I have to then, my lord,
You have enclosed the FIR, typed FIR,
my lord,
and thereafter the Indian Oil Corporation receipt and your gas connection card. There are 2 gas connection card and one is the payment receipt.
my lord, then it's a change brief, my lord, then I have to, my lord, tally this because in my reference copy also.
I don't have the other receipts, what my lord is saying. I don't have those in my petition.
My lord, then, my lord, kindly allows me to file a supplementary affidavit, my lord, kindly.
That is the problem. This is a matter of 2008.
My lord, change brief.
Now today,
It was a change.
will change.
No, my lord, it was a change brief. My lord will understand from the orders also, my lord. In 2020.
That's why I'm telling every time it will be changed.
No, my lord, it will not be changed. I hope.
When you came to know the criminal matter will be listed before this court.
My lord,
3 days before.
my lord, my lord. My lord, I was not aware.
Given the notice to the total bar, criminal matter will be taken first on every Friday.
Yes, my lord.
3 days before.
My lord,
So we are not having the document. Why you are not ready with that?
My lord, I am ready with my brief. My lord, actually, my lord, there is.
I am
There are certain.
I am vacating the interim order. You file whatever the supplementary affidavit. Then the trial
My
court
lord, kindly allows. My lord, kindly allows me, my
Sorry.
lord, 2 days. My lord, kindly allows me 2 days.
2008 now we are in 2025. 17 years you are enjoying the stay.
My lord, discrepancy. There are certain discrepancy between the records between of that is before your lordship's court and my lord with me. That is the discrepancy. My lord, the brief that has been handed over to me, my lord, I get to understand that this brief is not actually tallying with my lord's brief. Kindly, my lord, allows me to correct that. Thereafter, my lord, any day, my lord, I am ready, my lord, with my submissions.
2021 when the matter was disposed of, Dismissed. Why your state has not taken step before the trial court? 2021 and it was restored
My lord,
2025. What you have
they
done?
have not, my lord. We have completed our investigation, my lord, and my lord, my instruction is they have ready with the charge sheet. Probably they have filed it also.
No, 21 the matter was dismissed.
My lord.
And matter was restored. The 21 to 25 you have not filed the charge sheet.
My lord,
2008 matter.
My lord, we have what he is saying. He doesn't have the instructions properly, but my lord, we have filed the charge sheet.
When you filed? What is the date of the charge sheet?
My lord, 27 July 2010.
2010 you can't be.
Yes. Charge sheet number 27. My lord, this is.
Proceedings was stayed at that point of time.
That is where we are getting little confused. My lord, I'll call the investigating officer and I'll get.
My lord, may I also have a copy of the charge sheet from you?
How it can be?
My lord, from the trial court, my lord, after.
You go appear before the trial court, file an application, you will get the charge sheet.
After complying with the.
Yeah. And counsel for the petitioner. Press for time to file supplementary affidavit by disclosing all the documents. Let supplementary affidavit file within a week after serving the copy to the learned counsel for the state. List the matter on 5th of December 2025.
I'll get all those corrected.
The learned counsel for the state is also expected to take appropriate steps whether any charge sheet is filed or not.
Great.
I'll before the learned trial court. Yes, next.
Milord, I have filed this revisional application. Milord, at the same time, Milord, the state also filed an appeal.
Correct.
Milord,
That's why.
my lord, I have just, Milord, taken the server copy. Milord, that appeal, Milord, our High Court, division bench of our High Court. Milord,
take that.
Dada, it's down.
What are you doing?
Milord, their lordships have been pleased to maintain the Milord order of acquittal. So, Milord, my revisional application has no stands.
So what can be done?
Milord, dispose of this application. Because, Milord, the appeal has finally, Milord, the dismissed. The appeal filed by the state, it has been dismissed. So, Milord, I filed the revisional application. Milord, so, Milord, my case is not so strong that I will argue before your lordship.
Five accused persons have prepared this application. Status, you are the complainant.
I am the complainant. I filed the revisional
application. The petitioner being the complainant in connection with of which PS?
Nakashipara police station, Milord.
Connection with in connection with Nakashpira, PS case number 230, dated 26th August 1990, under section 341, 326 of the 302 of the IPC. The learned Sessions Judge Nadia had passed the judgment by convicting the accused persons for the offense and by acquitting the accused persons for the alleged offense under section 326 read with section 34 and section 302 of the IPC. Being agreed with the judgment passed by the learned additional session judge फर्स्ट कोर्ट नादिया ऊपर वही आएगा ऊपर जो बोला ना सेशंस जज बोला ना एडिशनल सेशन जज फर्स्ट कोर्ट नादिया dated 28 November 1996 the petitioner has prepared the revisional application Simultaneously, the state had preferred an appeal against the judgment dated 28 November 1996, being GA3 of 1997 within bracket State of West Bengal versus Ayat 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 SK and others. The division bench of this court had dismissed the appeal preferred by the state on 14th of July 2025. The copy of Learned Counsel for the petitioner has handed over the copy of the order passed by the Honorable Division Bench dated 14 July 2025 and submit that once the appellate court has already held that and already upheld the order of acquittal, and as such nothing remains to argue in the present division. In view of the submission made by the counsel for the plaintiff and considering the judgment passed by the appellate court dated passed by the Honorable Division Bench of this court dated 14 July 2025, the divisional application being CRR 817 of 1997 is dismissed. Interim order, if any, standard. Next.
But 14 kindly take up the matter next Friday or any day according to your lawsuit convenience.
Whether the all records are there on?
That is the issue. The records were called for. Trial court records and the records of the appellate court.
Trial court record is not on record. According to point director to place the TSR. आया record है?
What is it?
TSR है? Trial court record नहीं है? This appeal division against conviction.
No, it's a confirmatory order of conviction and sentence.
So record is required.
421, that is this. The
So
allegation is based on false document.
suspension of sentence is there.
Huh.
The department is direct, and this court find that the present revisional application is required to be heard after perusing the lower court record, trial court record. Accordingly, the department is directed to.
I am appealing for CBI.
To
Lower court record and also the record of the appellate.
To call for the trial court record as well as the appellate court record in connection and trial court record of which, where is the details?
Yes. CBI stroke SPE stroke ACB stroke Calcutta RC case number
record with respect
31 of 1995
CBI
dated
slash SPE slash ACB slash Cal RC case number 31 of 1995 dated 21st of August 1995 from the Learned Court of
Learned Additional Chief Judicial Magistrate Vidhan Nagar and also the
from the
records of the Court of the Learned Session Judge.
Vidhan Nagar, not 24 Parganas. That is enough. Appellate court is
Well,
on. Okay. This is the matter on.
This is the matter on.
12th December.
12th of December.
Lord, I beg to appear for
Yes.
the petition. But on the last occasion, it was partly heard by your lordship. This emanates from, my lord, non-payment of employees' provident fund dues. My lord, during the course of hearing, a very pertinent question was raised by your lordship, whether documents which have not been the part of the charge sheet, or I would say defense document, whether in a 482 application, lordship can peruse and can place reliance on such documents. Lord, I have placing two judgments on this issue. Lordship, this is 2008 judgment. My lord, this was passed by my lord Justice Altamas Kabir and Justice Kadzu. There are concurring judgments. Lordship kindly comes to the concurring judgment by Justice Kabir, which starts from paragraph 27. Now, Lordship kindly comes to para 31.
Yes.
Yes. In a three judges bench, the decision of this court in State of Orissa versus D.N. Padi, to which my learned brother has also referred, it has been mentioned as to how the matter came to be referred to the larger bench. Till 1996, the consistent view which has been taken by this court is that at the time of framing of charge, the trial court can consider only such documents as are placed by the investigating agency having regard to the language of section 227. At that stage, the defense could only be heard but could not have given opportunity to produce evidence for the consideration of the court. However, a different view was expressed by a two judges bench of this court in Satish Mehra versus so and so. The learned judges observed that if the accused are able to produce any reliable material at the stage of taking cognizance or framing of charge, which might fatally affect the very sustainability of the cognizance or sustainability of the case, it is unjust to suggest that no such material should be looked into by the court at that stage. It was therefore held that the trial court would be in its power to consider every material even the accused may produce at the stage contemplated in section 227 of the court. It was because of a discordant note being struck to an otherwise established principle in Satish Mehra's case that in D.N. Padi's case, an order was passed referring to the said decision to the larger bench, and the same was taken up for consideration in the case itself by the three judges. Then Lordship, para 34. The learned judges then went on to examine the earlier cases where the common view taken was that at the stage of the sections 227 and 228 of the court, all that the court is required to see is whether there is sufficient ground for conviction of the accused or whether the trial is sure to end in his conviction. The learned judge, while considering the other decision, also referred to the decision of this case in State versus Anti-Corruption Bureau versus so and so, wherein it was explained that at the time of framing of charge, the trial court is required to and can only consider the police report referred to in section 173 of the court and the document sent with it. It was emphasized that the only right available to the accused at the stage was that of being heard and nothing beyond that. In order to identify the parameters of the questions referred to, the larger bench observed that in a case before it in a question involved, it was nothing. It was not about the jurisdiction under 482 of the court, where along with the petition, the accused may file unimpeachable evidence of sterling quality and on that basis seek quashing. But it is about the right claim by the accused to produce material at the stage of framing of charge. The larger bench, therefore, was conscious of the limits within which it was required to confine its views, and the judgment was rendered in that context. The same will be evident from the opening paragraphs of the judgment. Now, my lord kindly takes the para 37. The larger bench did not leave any scope for a different interpretation of the provision of section 227 as is now being made. Incidentally, the very same argument has been advanced by Mr. Lalit before us on behalf of the accused, were also advanced by the learned counsel before the by the larger bench, and the same were negated as far as section 227 is concerned. However, in paragraphs 21 and 29 of the judgment of the larger bench, it indicates that the width of the power of the High Court under 482 and 226 of the Constitution is unlimited, whereunder, in the interest of justice, the High Court could make such order as may be required to secure the ends of justice and to prevent the abuse of the process of the law. In my view, there is no scope for the accused to produce any evidence in support of the submissions made on his behalf at the stage of framing of charge, and only such materials as are indicated in section 227 CRPC can be taken into consideration by the learned magistrate at that stage. However, in a proceeding therefrom taken under 482 CRPC, the court is free to consider materials that may be produced on behalf of the accused to arrive at a decision whether the charge as framed could be maintained. This is my view, this is my view appears to be to the intention of the legislature in the wordings of section 227 and 228, the way in which they have been worded, and as explained in DN Padi's case by a larger bench, wherein to which the same question has been referred. So a lot of distinction has been drawn between the materials which can be relied on by the defense at the stage of framing of charge,
Correct.
and while approaching your lordship under 482.
Correct.
So Supreme Court has said under 482, High Court is free to peruse any documents for arriving at a just conclusion.
Correct.
And my lord, the other judgment which I would rely on, it's a very recent one. Well, this is 2024. My lord, here defense documents were produced before the High Court, and the High Court was pleased to dismiss the revisional, the 482 application. The matter went to the Supreme Court. But from para 6, learned counsel representing the state of UP submit that the High Court does not call for interference, that the appellants have an efficacious remedy to challenge the order framing of charge by filing a revisional application. We are shocked to note the approach adopted by the state government. What is suggested by the state is that that once charge sheet is filed, accused cannot do anything except to wait till the charge is framed, and thereafter can file a revisional application to challenge the order of framing of charge. At this stage, the learned counsel appearing for the state submit that possibly because of the remedy of filing a revisional application against the order framing of charge are available, the High Court has dismissed the petition. We do not see any such reason forthcoming from the impugned order, as the petition is dismissed as infructuous without mentioning how it has become infructuous. It is true that the appellants can apply for discharge. However, the scope of application for discharge is completely different from the scope of a petition of quashing the criminal proceedings. While arguing a case for discharge, the appellant will not be in a position to rely upon any document which is not part of the charge sheet. The ground of abuse of the process of law will not be available while arguing discharge application. However, in a petition for quashing under section 482 of the Code of Criminal Procedure 1973 or under Article 226 of the Constitution of India, a wider challenge is available, including a challenge to the ground of abuse of the process of the law. In such proceedings, the accused can rely upon documents which are not part of the charge sheet. Therefore, we reject the submission made by the learned counsel appearing for the state. Though the submissions made on behalf of the state have no merits, we have dealt with it with the same elaborately to ensure that the same are not urged in a similar case. As the merits of the petition for quashing have not been gone into, we set aside the order. So, my lord, the position is, my lordship can look into documents which
No,
are
this is a 482.
482. Yes.
That's why I'm asking you.
Yes.
Yes.
Now, my lord, kindly, my case is, my lord, admittedly, my lord, for a period from March 1998 to December
Where is the FIR?
1999. My lord, this
Where is the FIR? 15.
FIR certified copy. Yes.
15. What is the allegation?
My lord, kindly
During the
take
inspection established
during
page-
our inspection. Yes.
Page 19.
Yes. Of the said establishment on so and so, it was noticed that the employer
Has deducted
which
as
so
per
and
the
so has
details
deducted as per the details and all the sum of rupees 2,92,000 from the salary wages of the employees as employees share a provident fund for a period of March
Yet
98 to
deposited
December
with the
99
statutory fund.
and have not yet been deposited the amount with the statutory fund in violation of section 6 of the act and with section 38 of the scheme. Non-remitting of the PF money.
So this is the only allegation.
This is the only allegation.
Where is the document you relied
Now,
on?
my lord, what I am going to your lordship kindly sees the date of registration of the FIR. Lordship kindly comes back to page 15.
FIR dated 26th September.
24th of September
No,
2001.
24th September.
Yes, 24th.
Where is that? Acha, 24th September.
Yes. And now lordship kindly takes the receipt challans, which starts from page 12.
Page 12.
Yes. and sees the endorsement of SBI. It was paid on 27th of June 2001. So 3 months prior to registration of the FIR, the entire due was cleared. So there was no cause of action to file the FIR itself.
So what was the amount mentioned there?
Well, 2,92,000 with penalty. I have paid more than 4 lakhs.
1,13,000.
This is 1,39,000.
39,665.
Yes. Then his lordship 26,684. Then his lordship 292,867. This three. It amounts to more than 4 lakhs. So there is no cause of action.
Whose name it was submitted?
Well, in the name of the company and one
By
director.
Provident Fund, share 03. What is the, have they taken the account number?
My lord?
Account number of the employee?
Yes, everything is mentioned.
No, in the complaint, which account number they are?
No, my lord. There is no reference to that the payment has been made. That is the whole difficulty.
Correct.
There is gross suppression of material fact in the FIR itself. And that vitiates the complete FIR. And my lord, thereafter charge sheet has been filed. This is more surprising. What the investigating agency has done, I am asking the question to myself.
What I'm asking, that is the answer. You find it.
Yes.
Account number
Of the department.
of the EPF, which you deposited, and the allegation in respect of which account? EPF account number. Details of the employee deducted the wages of the account number WB8. Kindly come to the 21.
Yes.
Page 21, last corner. Right hand side corner. 2882. This is account number.
Yes, 28882.
And the receipt is of the same.
Receipt 28882.
28882. Yes, that is the same.
Yes. 28882 at the top, the same.
Yes. Any further?
So, my lord, in this regard, I was relying on a few decisions of your lordship's court. What else? Yes. This is the coordinate bench of your lordship. My lord, kindly turns to paragraph 2A.
Yes.
Yes. The petitioners are directors of a company named as style so-and-so, which subsequently known as so-and-so, which had its place of business at so-and-so. A complaint was lodged by the OP number 2 so-and-so enforcement officer EPFO enforcement branch, which in turn filed with the officer in charge, SXPS Sarani police station, allegation entirely to the effect that so-and-so has deducted a sum of ₹31,000 from the salaries of its employees as employees share a provident fund contribution for the month of August 13, but had failed to deposit the same, and as then the fact came to the knowledge of the complainant in the course of inspection on so-and-so. The petitioners were alleged to be persons who were responsible for conducting of business of the said company. Thus, a prayer was made alleging criminal breach of trust and for initiating an FIR against the petitioners by 6th Sarani Police Station, so-and-so.
Yes, yes. Got
Now, lordship.
Here the charge sheet is filed.
Charge sheet filed and entire payment made. Para 2D.
And the 7A proceeding was also initiated.
Also initiated. 2D. It is the contention of the petitioner that on 17/10/2013, the complainant visited the petitioner's office and carried out an inspection under so-and-so, and due to the alleged default in payment towards so-and-so, amount to a sum of rupees so-and-so was detected. Pursuant to it, the notice was given to the directors of the company to make good the amount so defaulted. In the very same day, without accorded any time to the petitioner to pay the dues, the concerned Provident Fund Authority forwarded a written complaint to so-and-so for criminal breach of trust. On 28/10/2013, the complainant complied with the notice given by them, paying off the dues by check number so-and-so, drawn on so-and-so. On the next day, that is on 29/10/2013, the check paid to EPFO received the clearance, and the same is reflected in the bank statement of the complainant's account in UBI, and also from a combined challan dated 30th October 2013.
Yes.
Yes. Now, lordship turns to paragraph 5. After considering the contentions of the petitioner as well as the complainant, this court is of the view that it is the duty of the employer to deposit EPFO within 15 days by month, but they came to know about non-deposit of EPFO only after inspection by the complainant. Subsequently, they have deposited the entire amount along with interest as notice, and also it is admitted that the fact that the amount was credited. Accordingly, there is no dispute in the instant case regarding non-payment of employee share of provident fund contributions within time, but later company was deposited entire amount along with interest. Furthermore, it appears that the Honorable Supreme Court also quashed the proceedings of similar nature case. It is in the instant case also the entire amount along with interest having been as evidence as a copy of the check number so and so. There cannot be any justification for further continuation of the proceedings against the petitioner. With the payment of the entire dues, nothing remains outstanding. Further continuation of the proceedings will be sheer wastage of the time and money. In fact, Adonic Hotel Mills versus reported in
Yes,
so and
got
so,
it.
so and so.
That's all.
So these are my submissions. Do I place Adonic Cotton Mills? I am carrying that judgment, the Supreme Court judgment, which this court has relied upon.
Yes, what is the answer, sir?
I am for the state in this matter. Other two, opposite party number 2 and 3, I am not appearing. But if the case was initiated in 2001, if the charge sheet has been submitted on 2002, Lordship, thereafter, they have not appeared in a single days before the learned court below. Lordship, kindly see the last 2 pages of their application. Last 2 pages. The order sheet, Lordship, kindly see.
Last 2 pages of the application.
Yes, of their application. Order sheet.
Yes.
Lordship, kindly see 18th of June 2004's order. Thereafter 15th of 10. They are not appearing. This is their conduct.
So stay order by this court.
No. There is no stay order.
Yes. June 2008.
Yes.
There is an stay. Shall remain stayed until further order.
Yes.
13 June 2008. The let all further proceeding of each so and so pending before the learned judicial magistrate third court Alipu shall remain stayed until further order. Subsequently, it was stayed. In your charge sheet, you are having the charge sheet.
Yes.
Charge sheet is the receipt which the petitioners are relying upon. You are collected that receipts during investigation. P1, which the petitioners are relied upon, 12, 13 and 14. Has the investigating agency has seized that and relied upon?
Lordship, kindly see 13, page, inner page 2. The charge sheet, page 13, particular.
Charge sheet is not here. That's why I'm asking. You are having charge sheet. So that's to show me whether your investigating officer has considered this document and exactly come to know that this is not payment related.
We do not know whether they have submitted these 2 challan before the investigating officer or not.
That is different thing. How they will submit? Have you issued the section 90 notice for production of document?
Must be.
To the accused?
Must be.
It is the investigating officer has to ascertain what is the complaint.
They are directed to cooperate in their bail application.
Sir, I am asking only one question. This paragraph, page 12, 13 and 14 relied in the charge sheet. Kindly see the list of documents of your charge sheet. No. Then is there any averment in the charge sheet that this document has been seized? What is the date of charge sheet?
June 2002.
2002.
Yes.
Then these are of 2001.
Yes.
But why the investigating officer has not seized this document?
They have not submitted.
Investigating officer has to.
In their
It is the official document. The investigating officer has to seize the document from the office.
they got anticipatable before the learned High Court.
Maybe.
Honorable High Court.
Maybe.
So, they are directed to cooperate the
Correct.
investigating officer.
Correct. Have you filed any application? They have not cooperated.
That is what is the case, if you will not see.
That's all. The petitioner has filed the present revisional application.
Kindly record, I am opposing this.
Yes, yes. Total opposition I will report, don't worry. Has filed the present revisional application being CRR of 1574 of 2008. Praying for quashing of the proceeding in EBGR case number 30 of 2001 pending before the London Judicial Magistrate, Third Court, Alipur, South 24 Pargana, arising out of Bhawanipur PS case number 321 of 2001, dated 24th of September 2001, under section 406 of the Indian Penal Code, and the further order passed by the London Court in this said proceeding. The on the basis of the written complaint of enforcement officer, Employees Provident Fund Organization, West Bengal, dated 13th June 2001. Complaint dated 2000. That is the 13th June 2001. Complaint dated?
Yes.
And the FIR was stopped when?
FIR is 24th of September 2001.
After 3 months.
After 3 months.
2001. And on the basis of the said complaint, the above case was registered by the police of PS Bhawanipur for the offense under section 406 of the IPC on 24th of September 2001. The mute question in the allegation in the FIR is that during the inspection of the establishment on 13th June 2001, it was noticed that the employer, that is the petitioner, namely Suresh Kumar Bhagla, has deducted an amount of rupees 2,92,509 from the salary of the wages of the employees as employees' share of provident fund contribution for the period March 1998 to December 1999, but has not deposited the said amount with the statutory fund, and accordingly the petitioner has violated the provisions of section 6 of the what is the act? Section 6 of the what? Employees Provident Fund Act. Section 6 of the Act. Read with para 38 of the Employee Provident Fund Scheme. On the basis the mute question, the petitioner in the present revision application under section 482 of the Code of Criminal Procedure has relied upon 3 challan deposited with the State Bank of India, NS Road, Kolkata, on 23rd of June 2001, 27 June 2001, and 12th July 2001, with respect of the amount 1,39,665, 26,684, and 2,92, and 29. What is the last amount? What last receipt amount? Page 14. What? 2 lakhs. 2 lakhs 92,867.
Yes.
867 respectively. Respectively. The learned counsel for the petition contend that though the complaint was made on 13th of June 2001, but subsequently on 27 June 2001, 27 June 2001 and 12th July 2001, the petitioner has deposited the said amount with the State Bank of India. But the investigating agency during the investigation has not considered the said document. He submitted that though the complaint was made on 13th June 2021, but the FIR was registered on 24th of September 2001. Subject 2001. But the FIR was registered on 24 September 2001. On the date of registration of the FIR, the petitioner had already deposited the said amount in the statutory account. Thus, there is no case made out against the petitioner, but without considering the said challan, the police has submitted charge sheet against the petitioner for the offence under section 406 of the IPC. Learned counsel for the petitioner has relied upon the judgment in the case of Rukmini Narvekar versus Vijaya Satadekar and others, reported in 2018, volume 14, SCC, volume 1, and submit that the Honorable Supreme Court has categorically held that though there is no scope for the accused to produce any evidence in support of the submissions made on his behalf at the stage of framing of charge, and only such materials are indicated in 227 can be taken into consideration by the learned magistrate at this stage. However, proceeding taken therefrom under section 482 of the CRPC, the court is free to consider materials that may be produced on behalf of the accused to arrive a decision whether the charge as framed could be maintained. Learned counsel for the petitioner has further relied upon the judgment passed by the Honorable recent judgment passed by the Honorable Supreme Court arising out of a special leave petition within bracket criminal CRL number 12354/2024 within bracket Mukesh and others versus the state of Uttar Pradesh, dated 29th of November 2024, wherein the Honorable Supreme Court has further held that a petition for quashing either under section 482 of the Code of Criminal Procedure, 1973, or under Article 226 of the Constitution of India, a wider challenge is available, including a challenge on the ground of abuse of process of law. And in such proceeding, the accused can rely upon the documents which are not the part of the charge sheet. And the counsel for the petitioner further relied upon the judgment in the case and the judgment passed by the coordinate bench of this court in the case of Vishal Kocha and another versus State of West Bengal and another, reported in 2024 SCC online, Calcutta, 6536. 6536, wherein the Honorable Court has held that the entire payment dues there cannot be any justification for further continuation of the proceeding against the petitioner when the payment of entire dues have been paid. Counsel for the petitioner submitted. In the present case also, though the complaint has been made that the petitioner has deducted the amount from the salary or the wages of the employees, but has not deposited in the provident fund contribution account, but failed to consider that the petitioner has deposited the said amount, which is appearing at page number 12, 13, and 14 of the present divisional application. He submitted this a fit case wherein the proceeding initiated against the petitioner is required to be quashed, is liable to be quashed. Full stop. Per contra, learned advocate appearing for the state submits that the case has been initiated in the month of September 2001, but and after the initiation of the case, the petitioner has got an anticipatory bail, but has not cooperated with the investigating agency. The petitioner has not supplied the said document which the petitioner is relying upon in the present revisional application. He further submitted that the investigating agency has completed the investigation and found that the petitioner has found that the petitioner has committed an offence under section 406 of the IPC and accordingly charge sheet is filed. He further submitted that if the petitioner relied upon certain document, the petitioner is at liberty to rely the said document at the time of trial, but not at the stage of hearing of the revisional application under section 482 of the CRPC. He prays for rejection of the present application. That's all. Anything further? At the learned counsel for the parties, this court find that the FIR has been initiated on the specific allegation that the petitioner has deducted an amount of rupees 2,92,509 from the salary of the wages of the employees as employees' share of the provident fund contribution for the period of March 98 to December 1999, but has not deposited the said amount with the statutory fund and has committed the offence under section 406 of the IPC. The complaint was made on 13 June 2001 and the FIR has been initiated on 24th of September 2001. By that time, the document which the petitioner has relied upon, that is page 13, 12, 13 and 14, reveals that the petitioner has deposited more than the amount as mentioned in before with the State Bank of India. State Bank of India on 27th June 2021, 2001 and 12th of July 2000. After the initiation of the FIR, investigation has been carried out. A specific question was put to the learned advocate appearing for the state whether in the charge sheet the investigating officer has collected the document which the petitioner has relied upon. In the fairness submission of the learned counsel appearing for the state submitted that there is no reflection of the said document. This court find that considering the above, this court find that the allegation on the basis of which the case has been initiated against the petitioner for the offence under section 406, the petitioner has already deposited the said amount with the State Bank of India. But neither the complainant nor the investigating officer have taken into consideration of the amount deposited by the petitioner in the State Bank of India on 27th of June 2001 and 12th of July 2000. This, if, full stop. If at this stage the document which the petitioner relied upon is not considered by this court, comma, this court is of the view that will be a abuse of process of law. Abuse of process of law. The petitioner can produce the said document before the court, the result would be same. Thus, this court has accepted the submission made by the counsel for the petitioner and accepted the document relied by the petitioner that the petitioner has already deposited the amount before the registration of the FIR, but the investigating agency has not considered the document which has been deposited by the petitioner before the State Bank of India. Considering the above, this court find that this is a fit case. This court this is a fit case for quashing of the proceeding initiated by the police of PS Bhawanipur, being FIR number 321 of 2001, dated 24 September 2001, under section 406 of the IPC. Accordingly, the proceeding initiated against the petitioner, being petitioner by the police of PS Bhawanipur, being FIR number so dated so under section 406, and the proceeding pending before the learned, which court? Which court it is pending?
Judicial Magistrate, Third Court, Alipur.
Judicial Magistrate, Third Court, Alipur, South
24 Parganas.
South 24 Parganas, being EBGR case number 30 of 2001, is also quashed. The petitioner is discharged from the bail rank, if not recorded in any other case. Next.
16, I'm appearing for the petitioners.
Yes.
And before I start, there are two petitioners before your lordship. One of them has expired during the pendency of application. My difficulty is this, that I do not have any death report or death certificate. I have received the instructions. So if your lordship pleases to call for a report or something like this.
Who is for the state?
Millet, this is a complaint case, Millet. I am a
ना हमारे लोग होता है हमारे लोग
I am for the de facto complaint here, Millet. This is a complaint case under 138 pending since 2004, Millet. Millet,
you are appearing for
the complainant, my lord, opposite party.
Yes.
So, Millet, what I am saying, Millet, this matter was dismissed for default in the year 2021. Subsequently, Millet, the learned trial court, Millet, I have the order sheets also, Millet, after the matter was dismissed for default, the case has proceeded. The warrants of arrest was issued against both the accused persons, my lord, which are petitioners before your lordship. It is true, my lord. Subsequently, my lord, the accused number 2 or the petitioner number 1 herein has prayed for bail before the learned trial court, and the same prayer has been made before the learned trial court, and the learned trial court has been pleased to call for that record. So, my lord, I am praying, my lord, at this stage, this petition is not meant. I have the order sheets, Millet.
No, the report has not yet been submitted before the
Millet, they have to submit the order. Millet, they have to submit they had undertaken to submit the death report.
Probably my learned friend is not aware of that procedure. Well, it has
yeah, sure. Show the order sheets.
Millet, these are the original order sheets. Millet, will see. I'll show the last 2 order sheets only, Millet. Millet, even if Millet, this application for condonation of delay is today, Millet, I am opposing that, Millet. All these procedures can be done before the learned trial court, Millet, and the case can be proceeded.
But this court failed to appreciate why the complainant is waiting from 2009. Why you're not taking appropriate steps?
Millet, we have taken steps, Millet. They have appeared, taken bail, Millet. We are going here for trial, Millet. Now they are praying time before the learned trial court after appearing, Millet.
Itself is not
warrant is no year of warrant of arrest is received.
Millet, we cannot go into the merits first. The application has to be admitted, my lord. Your lordship has to condone the delay, my lord.
Still the condemnation is delayed.
No, my lord.
occasion when it was taken up for hearing on the last day, if you are kind enough to see the last order, on that day I prayed for an accommodation since my last junior was not there. So your lordship was pleased to hold that the hearing of this application for restoration as well as the condemnation of delay in preferring the restoration along with the main application will be taken up for hearing. If your lordship wants to hear out the matter on merit, I am ready with that. It's ready with the matter.
Praveen Mitra is appearing.
Praveen Mitra is
Fine
appearing.
bail, furnishing bond of rupees 1,000
Yes.
of one surety.
The
Okay.
initially
And with regard to the other, Prashant Kumar Ghosh,
that is why, Millard,
appearance of the the company director.
Prashant Kumar Ghosh has expired. I do not have any document to satisfy your lordship that he has expired. If my learned friend has a document, let the.
I am not supposed to give any document.
That is why we are submitting that either the report has to be placed before the learned magistrate court from where a judicial satisfaction has to be there that this contention is true, or Millard, there has to be a report before this court that.
Millard, will that be done before this court?
The check amount. Millard, the check amount is 25 lakhs and check amount is Millard.
25 lakhs of the year 2004.
69,190.
Of year 2004.
Millard, if my learned friend continuing interjecting,
Millard.
then I cannot, Millard.
Yes, Millard.
Millard, the issue remains over here is this, that when a winding up order.
Millard, before that, before my learned friends, Millard, only, Millard.
I will not pass any order without hearing.
No, Millard, only I am saying is, Millard, I am on the preliminary objection of admission of the.
Yes, I understand.
Millard, and the Supreme Court judgment says that without.
Understand, sir.
Millard, may only say one thing, Millard. Millard, without getting into the merits, Millard, they have to first satisfy this court why the application for condonation of deal has to be allowed. Millard, that has been held by the Supreme Court. Millard, they cannot get into the merits, Millard. Millard, for 3 years, they keep it pending. Millard, they cannot go into the question of merits now, Millard. Yes, Millard. Yes, Millard, I am objecting.
This court is not going that part.
Millard.
First, the court has to. Please, sir. This court has to first ascertain whether both the petitioners are alive or not. One petitioner is expired. The record is to be corrected first.
My lord.
Correct.
Very well.
You are the complainant.
My lord.
You have to ascertain first. And he is appearing for the petition. He is also due to report this.
Very well, my lord.
So neither you are submitting nor you are submitting. I am passing an order directing the which PS.
My lord, please.
Directing the PS to submit report.
But they're in Delhi, my lord. Delhi, my lord. They're all of Delhi. Yes, my lord. They're all deciding in Delhi, my lord.
Yes, you are appearing. You are not having the knowledge.
My lord, I do not practice. I have a knowledge, but I do not have the document to satisfy your lordship. That is the difficulty with it.
What document?
The trade certificate or something like this, my lord.
The warrant of arrest also, there is nothing on record.
My lord.
Which PS? Delhi, which PS? Anwar Shah Road, Kolkata. How you are telling the Delhi? It is Anwar Shah Road, Kolkata. Prashant Kumar Ghosh.
No. My lord, they have the Prashant Kumar Ghosh is Anwar Shah Road. Having his office that he is given. Okay. My lord, the complaint has been filed.
Where is the complaint? Where is your complaint?
Page is page 16, my lord.
Page
16. 16.
Petition.
Finance director, Mr. What is the company name?
MK International Limited.
Having office Prince Anwar Road, Kolkata.
Miller, very well. It's Kolkata. Miller, I stand corrected, Miller.
What is the company name?
Miller, the
eligible.
Miller,
Director. The accused number 3, that is the petition number 2, is
MK.
Given is the MK. MK International Limited, giving the finance data. That is the company's address. My lord, the police station of the complainant is passed.
Oh, you obtain from the master data whether the director is there or not.
My lord, what I am seeing is, my lord,
that master data will not be available because the company has been owned up.
My lord, what I am saying.
Has been owned up on the day when the check was cause of action did not act.
My lord, what I am on is, my lord, will seize the order. My lord, the certified copy that I've given, my lord. My lord, the order date is 13th of August 2025. My lord, I read the order, it's handwritten. The complaint is present. The accused number 2, who is the petitioner who is appearing before lordship, is absent. No ER of accused number 1, no DR of accused number 3. So, my lord, it has been informed to the learned trial court that the accused number 3 or the petitioner number 2 before lordship is dead. If your lordship wants to satisfy for the ends of justice of this case, let my learned friend get that document. I am not in the way of that document being produced in the court. However, my only objection is this
application for condonation of delay should not be
That
admitted.
cannot be taken unless the record is clear.
Very well, my lord. My lord, if that
Record can be clear. Record is clear whether because if the dead person is there, how the court can pass an
very well, my
consequence order?
lord, if they will be in personal knowledge of that, my lord, if they can.
Why I am submitting that although I have a knowledge that this person is no more in the world, but I cannot have any document to satisfy your lordship that this person is no more in the world.
It is informed by the learned counsel for the parties that the petitioner number 3, petitioner number 2 or 3?
So the petitioner number 2.
Petitioner number 2, namely Prashant Kumar Ghosh, GHOSC,
Draft petition.
Finance Director of Messrs. MK International Limited, having his office at 58/45 Prince Anwar Shah Road, PS. What is the PS Lake? PS Lake, Kolkata 70005 is passed away. Learned counsel for the complainant has also drawn the attention of this court to the order sheets of the learned trial court, wherein it found that against both the accused persons warrant was issued, and against the warrant the accused number 1, namely Prabir Mitra, had up.
Accused number 2, my lord.
Accused number 2.
Petitioner number 1 and accused number 2 before the trial court.
Accused number 2, namely Prabir Kumar Mitra, accused number 2 / petitioner number 1 before this court, has surrendered before the learned trial court and he has got the bail, but there is no report against the petitioner number 2 / accused number 3 before the trial court. Accordingly, the petitioner is directed to submit the report before the next date fix, as also direct the officer in charge of PS Lake, Kolkata, to submit the report whether the Prashant Kumar Ghosh is alive. Respondent number 2. Yes, you are also filed. You have also to file the report, give the report, obtain.
I do not have any document to satisfy. That is the difficulty with it.
You are the petitioner.
I am the petitioner, but
Either you withdraw the power.
Today the power is no more in existence.
I don't know, because if the power is tomorrow, somebody will come. I am the Prashant Kumar. Then what will happen?
Difficulty, Milord. I have tried. I could not.
ऊपर क्या बोला? Petitioner. Accordingly, the officer in charge, PS Lake, Kolkata, is directed to submit a report with regard to the status of Sri Prashant Kumar Ghosh, Finance Director of Messrs. MK International Limited, having its office at 58/45 Prince Anwar Shah Road, Kolkata, on the next date fix. Let the matter appear before this court on 28th. 5th of December.
Miller, may I only not say 5th? Miller, 5th is the date before the trial court. One day before would also suffice. Miller, I am before.
By 28, what is the problem?
That is why.
Let the report come.
In your view, Lordship has asked to argue the matter, then I will be.
No, let the report come.
Well, then I may not be able. If I am available, I'll do the matter.
Well,
if not, then I'll.
28 for filing report by the officer in charge, Lake Police Station.
Miller, nobody is here for the state, so Miller.
The petition is directed to communicate this order to the officer in charge, Lake Police Station, for compliance.
Miller. Deeply.
Next. Give that, please. Certified copy. Give. Okay, keep with the record. Next.
Item number 17.
Milord, in item number 17.
The petitioner followed
Milord, I am just praying for a short password. Milord, I am led by Mr. Gangu.
Let it what the CBI says. First, we have to give the preference. Nowadays, the CBI.
There is a delay, 43 days. Malord, 2009 matter, not yet in Malord delay condone. That's why Malord divisional application could not be heard. Well, let me, my lord, section 5, my lord, subsequently, in the meantime, it was dismissed for default, that was restored. My lord, kindly condone the delay and fix for the matter. This is, my lord, it's a short matter. My lord, by forging documents, my lord, don't have.
Why the CBI before this court?
My lord, because my lord, discharge petition prayed for, that is
Discharge.
allowed. My lord, against that.
Against the discharge order?
Yes, against the discharge. My lord, only score on that score that he has been paid entire amount. My lord, he has paid entire amount, that's why, my lord, discharge. My lord, if, my lord, offense has been committed, even if, my lord, my lord, kindly condone the delay and fix for it.
Milord, I am only praying for a short password. Milord, kindly fix at 1 p.m. I am led by Mr. Ganguly. I am for the opposite party number 2 and 3. Milord, Mr. Ganguly will come, and then Milord,
I am not the.
It will be hard.
The matter, only one of.
But what about the section?
that is the
5?
instruction. I have him. Milord, kindly.
Sir, that's why. My lord,
Okay, I am passing it over. Let me pass over.
I'm grateful, Milord.
My lord, in this matter, my lord, I have found that, my lord, the matter was disposed of on 30th of March 2023, my lord.
Huh?
This matter, my lord, was disposed of on 30th of March
Where is the order?
2023. Well, I have checked it through the net, my lord. My lord, just now.
Which date? What is the date order?
30th March 2023, my lord. My lord, your lordship's kindly.
2003?
2023, my lord.
2023?
My lord.
Ekta check karo.
My lord, this is the, my lord, if your lordship, my lord. Pardon me, my lord. Just check it
check
up, my
karo.
lord.
Order.
It has already been disposed of. So 125 matter I have found, my lord. The husband filed, my lord. Last page of order, my lord.
You can get the order from this.
এখান থেকে পাবেন তো অর্ডারটা একটু বার করে দিন না
You can get the order from this
Yes, yes,
system.
my lord. It's available here.
CRR 4049. CRR 4049 of 2009. 4049 of 2009, dated 30 March 2003. 23. 30 March 2003. Got it?
দুটো অর্ডার আছে দেখবেন
None appears on behalf of the petitioner. Learned counsel for the state is present and handed over the copy of the order passed by this court dated 30th March 2023, wherein the present revisional application is dismissed, is disposed of. Accordingly, the department is directed to correct the status of the present case in the website as disposed of matter.
Deeply village, my lord.
Next. Hmm? Hmm. Judgment. Why 40? Why the two numbers? 49. Might be number is wrong. That I have asked. What is status says? Status pending. 30th March 2023. Fixed. You give me. There is some mistake. Huh? Wrongly typed. You have to check the cost at the cost list of 30th March. Two 2023. Twenty-three. CRR 4049. 236. Code number 236. Key. Siddharth Chatuk. Item number 13. 13. Jaydev Mandal. Jaydev. Jaydev Mandal. Take print. CRR number. The Learned Council for the and at counsel for the petitioner and respondent state. Name in the order. Huh? And then I will order the order passed by this court in CRR number 4049 of 2009, dated 30th March 2023. In the cause title, the name of the petitioner is wrongly recorded as Ranjan Majumdar. The cause title of the order. In the cause title of the order, and the cause title in the order, the name of the petitioner in the cause title of the order is wrongly recorded as Ranjan Majumdar instead of Jaidev Majumdar. Mandala. Accordingly, the department is directed. Accordingly, in the order dated 30th March 2023, passed in CRR 4049 of 2009. The name of the petitioner shall be read as Jaidev Mandal instead of Ranjan Mandal. The department is directed to correct the status of the case in the website as disclosed. Thank you. This one where am I? You keep this. Yes, call them. Item number 19. Nobody is there. It is fine from the record. The matter was listed on 7 November 2025, but none appears on behalf of the author of the parties. Accordingly, for the interest of the case is adjourned till today. When the matter is called today, none appears on behalf of either of the parties. No accommodation is sought for. Let the matter fix for order. Let the matter fix for orders. I will pass. Next. Yeah, so for who is appearing for the petitioner?
The Saurabh Chatterjee was appearing at some point of time.
Saurabh Chatterjee. What is the application? 482?
Yes, Malord.
397, 482. Challenging the order of conviction.
The revision against conviction, Malord.
Revision against conviction. By the appellate court also.
Malord,
what is the offense?
Malord, they were sentenced to suffer for 3 years. The offense is under section 3A of RPUP Act.
My lord, page, internal page 30 of the judgment, my lord, your lordship will see the ordering portion.
Page 30,
Internal page 30 of the judgment, my lord, which is annexed with the petition.
accused, four accused persons
Yes, my lord.
found guilty for the under section 3A of the RPUP Act.
And
Attorney convicted
sentenced to
like
serve 3 years.
3 years and to pay.
Fine.
There is an stay.
No, but yes, my lord, when the division application was admitted, it was state, my lord.
Stay. And thereafter nobody is appearing. Today also none appears.
In fact, once, my lord, this was dismissed for default and was restored, my lord.
It was restored by an order dated 16 December 24.
Yes, my lord.
Thereafter nobody is appearing. As none appears on behalf of the petitioner, for the interest of justice, the case is adjourned. Let the matter appear on 28th of December 28th of November 2025. It is made clear that the date fixed, if none appears, the necessary order will be passed.
Right. 28th November. 28. ये कागज को
Next.
But I am for the petitioner.
Yes.
But this is for washing off of proceedings against officials of the bank. Lord, what has happened? The opposite party number 2 obtained loan for purchase of a 4-wheeler.
Opposite party number?
The opposite
You are
party
appearing
number
for the accused persons.
Yes, the opposite
Washing
party
FI.
number 2 obtained a loan from HDFC Bank for purchase of a 4-wheeler. Subsequently, they defaulted. We took repossession of the vehicle as per the stipulation in the agreement. Upon giving notices to the concerned police station, both pre and post, thereafter the de facto complainant was put to notice that, look here, you have defaulted, we have taken repossession. You pay the money within 15 days, failing which we shall be constrained to invoke the provision of sale as per the loan agreement. And thereafter, we have sold the vehicle. But after getting the notice of sale, almost after 1 month, the de facto complainant goes to the court without going to police or to the superior police officers. So there is non-compliance of 154, 1 and 3. Directly goes to the court and takes out an application under 156.3. And which leads to the registration of the instant case. Now, my lord, would kindly turn to the FIR.
There's a direction for FIR.
Yes.
The 156.3.
Yes.
Then FIR chalked out.
My lord, the certified copy. There are 9 accused persons in the complaint who have been made vicariously liable. But surprisingly, HDFC Bank is the principal offender, has not been made an accused in the petition of complaint, in the FIR, I would say. My lord, kindly comes to paragraph 3 of the FIR. That in the year 2007,
Where is the FIR page number?
my lord, this is certified copy, it's not paginated. It is the last document of your lordship's brief. The lordship got it? But after page 34, it starts.
Yes.
Yes. The lordship kindly comes to paragraph 3.
Yes.
That in the year 2007, the complainant wanted to purchase a car of Chevrolet company, namely Tavera, being model number such and such. The complainant did not have the necessary funds to purchase the said vehicle outrightly and was looking for a financer. At this time, he came to know that the accused persons who are posed at the auto loan department of HDFC Bank Limited can arrange for funds required for purchasing the said vehicle. Accordingly, the complainant made the officials of the bank car loan department at Gallender House, Kolkata, when he was told that the HDFC Bank can arrange for funds for purchase of the vehicle, provided the complainant makes over to them 60 undated checks for a sum of rupees 1 so each, which will be deposited on the 7th day of every month, commencing from 7/8/2007 till 7/7/2012. So the tenure was 60 months. The bank will directly pay the amount to the dealer and the said vehicle, namely Indian Automobile 19 so a sum of rupees 6,85,000 out of the consideration of 6,88,800, and the complainant should have to pay the balance consideration of the vehicle as also necessary charges towards registration of the aforesaid vehicle and obtaining insurance thereto. The complainant agreed to the proposal of the bank and he was made to sign a car loan application form. Though the complainant asked for copy of the same, he was told that the same would be given to him after the first installment is paid, but till date, in spite of repeated requests, the said document has not been made over to the complainant. The complainant was further made to sign at various places purportedly on a loan document that the complainant was entering along with the bank. Like the car loan application, this car loan application was also not made over to the complainant in spite of requests made by him. The complainant made over 60 undated checks to the HDFC Bank Limited, and the bank accordingly paid a sum of rupees 6,85,000 to so and so, whereas the complainant paid the balance consideration and the necessary money required for registration and obtaining insurance. At the said vehicle was registered as so and so, the complainant was not only made over a payment scheduled by HDFC Bank. A copy of the annex letter is annexed here. So then paragraph 4. The complainant may be a little late, but was diligently paying the installments as per schedule. But I will show you to your lordship from the statement of accounts that there were persistent defaults since the very inception of the loan. The complainant last made payment of the installment on 18/11/2008. Then, my lord, the allegation in paragraph 5, that is utter dismay when the complainant was returning from the airport on 16/12/2008 to his office, an Innova car of Toyota make crossed the aforesaid vehicle and forced the complainant's vehicle to stop just when he crossed Subhas Sarovar Lake, Beliaghata. This happened at around 10:30 hours. Accordingly, he stopped the complainant. Immediately after stopping the complainant's vehicle, 6-7 persons came down from the Innova vehicle and being asked about the reason why they have stopped the vehicle, they told that they are employees of HDFC Bank and they have stopped the complainant's vehicle in order to make repossession of the same, and the complainant had defaulted in making payment of the installments. When they came to learn that the vehicle was standing in the name of the complainant, they started abusing the complainant in filthy languages, and after opening the door, dragged the complainant out of the car and assaulted him mercilessly with fists and blows. The driver of the complainant was also dragged out and assaulted in same manner, in which the complainant and the driver suffered huge pain on their bodies. The aforesaid person thereafter, on the threat of a gun, drove away the complainant aforesaid vehicle after forcing the driver of the complainant to sign on a printed form. The attache case of the complainant, which was lying in the aforesaid vehicle, was also stolen by the aforesaid miscreants. Apart from the business documents, a sum of rupees 25,000 was also lying in the attache case, and the same was stolen away by the accused persons. It may be pertinent to mention herein that the activities of the said persons have been done as per the guidelines framed by the accused number 1 to 7 and as per the directions of the rest of the accused persons. The complainant immediately went to the local police station, informed them verbally about the incident, when he was told that police will take appropriate steps in the matter. That thereafter, by letter dated 29/12/2008, the complainant requested the bank to return the vehicle and agreed to make payment and of whatever of their dues. The complainant thereafter had been to the bank on several occasions and interacted with the officials of the car loan department, HDFC Bank at Gallender House, and they, on one pretext or the other, dilly-dallied to return his car. Suddenly, the complainant received the letter dated 6/1/2009 issued by the bank informing the complainant that his car was sold. So this is what has triggered my lord, the lodgement of the FIR. The complainant was totally taken aback at such behavior of the bank officials and immediately rushed to their office at Gillander House on 14/1/2009, when they were told that the complainant will not return the car and the complainant can take any steps whatsoever he chose, and he will not, and they will not return his car. They also told, my lord, latter part is not.
So this is an incident.
This is the incident.
As
Now, my lord, first I would take your lordship to the loan agreement, which appears at page 18. The first question would be whether taking repossession is
You
as
are appearing
per
for the estate. You are appearing.
Your worship, for defective complaint, your worship.
is
For the state, he is for the defective.
Yes. My lord, kindly comes first to page 20. What are the events of default and what will be the consequence of the default? Page 20, lordship sees clause number 11 at the bottom.
Yes.
Events of default. Now the borrower expressly, irrevocably, jointly and severally agree that the bank, that in the event of the borrower fails to make any sum due from him or from it or him therein, so there has to be a default in repayment of the loan as per schedule. Then what will be the consequence? Now lordship comes to the enforcement on the next
What has
page.
happened to the car?
Car we have sold to a third party as per the stipulation in the agreement.
Okay.
I will show that. My lord, then lordship comes to clause 14, the enforcement. On page 21.
Yes.
Yes. If the borrower fails to perform any of the obligations herein, and the same is not remedied to the satisfaction of the bank within the period to be specified by the bank, any event of default pursuant to clause 11, then in that case, at the time thereafter, the bank through its agents, officers and nominees shall have the right to take any one of the following actions without the specific intervention of a court or any court order. Then 1, Roman 1, without any notice and assigning any reason, and at the risk and expenses of the borrower, and if necessary, as attorney for and in the name of the borrower, take charge and or possession of, seize, recover, appoint receiver, and to remove the hypothecated vehicle. The bank will be within its right to use tow van to carry away the vehicle. This is the IA. And then lordship kindly comes to Roman 3. Sale by auction or by private contract or tender, dispatch or consign for realization or otherwise dispose of or deal with the hypothecated vehicle in the matter the bank may think fit. So my actions under the agreement, there is default. I repossess the vehicle, give him notice to pay. He ignores the notice. I sell the car to a third party, immediately rushes to the criminal court. There is no representation before police. I have shown it to your lordship. He says there was a verbal complaint. Then, my lord, no representative to superior police officers, straight away goes to the court and takes out an application under 156. The direction is passed. Now, this is contrary to the law, my lord, declared by the Honorable Apex Court and this Honorable Court on thousands of instances. Now, lordship next comes to the statement of accounts, which is at page 25. My lord, I am showing this document. These are all records kept by the bank, which are under section 5 of the Banker's Book of Evidence, prima facie evidence, which lordship can look into in a 482 application. Lordship,
can I interrupt for a moment? I'm just requesting my learned friend to show that what procedure they have opted to take the recovery of the possession of the vehicle only. That is the main cause of action related to this complaint. Others, whatever my learned friends is argue, it's related to the civil matter. The arbitration clause is there. For those things, you can approach to the arbitration court, your lordship.
Arbitration of?
Arbitration clause is there, your lordship. For recovery of the possession, your lordship, they have right to go with the section 9.
Correct.
To take that.
My lord, law is not at.
We are only with that, ki what procedure you have opted to recover the possession, whether you have followed the law or not.
This is the simple question here.
My lord, law is
That's
no
it,
more
Your
res
Lordship. My
integra.
friend can
Both
continue, Your
go on
Lordship.
simultaneously. Whether
Where is the,
only
where is the sale procedures, sale proceedings?
yes, Lordship, finally, first Lordship sees that they have defaulted in making payment. My lord kindly comes to
Okay,
page
defaulted, okay, where is the, what procedure you adopted? So what proceedings you have taken into consideration? when you have taken-
for repossessing and sale of the vehicle. Okay. My lord, this is the at page 29 is the notice where we have recalled the loan and requested them to make payment, which was not adhered to. Page 29.
Yes.
Lordship sees the amount 6,73,300 rupees. This was given, my lord.
Page 60.
29. 2/6/2008.
Yes.
Yes, this is the loan recall notice. The entire loan, the first point, principal interest is being recalled forthwith. Then Lordship kindly comes to page 30. This is on the date of repossession. Our notice to the concerned jurisdictional police station, which is Jadavpur police station. This is a pre-repossession notice. We bring it to the notice of the concerned police station that we are taking repossession due to default committed by the borrower.
Yes.
My lord kindly comes to the next page, page 31. After we take repossession, this is the post-repossession notice. And in every notice, Lordship sees the stamp at the bottom of the concerned police station. On the same date, we take repossession. We inform it to police.
This is a notice to the police authority
Yes.
informing.
Yes.
Then
Then is the inventory of the vehicle, where at the bottom Lordship would get the signature of the driver of the vehicle.
Satyendra Yadav.
Satyanarayan Yadav.
Yes.
So even, my lord, it was signed. Then Lordship comes to page 33, which is a notice prior to sale of the vehicle. This is to inform you that the said vehicle hypothecated to HDFC Bank Limited, of which we have recovered possession due to your defaults on non-payment in monthly installments by you, shall be sold by the bank in terms of the power conferred upon under the loan agreement and has been executed between us. In the event you wish to obtain release of the vehicle to yourself, the total dues outstanding and overdue interest, including collection, repossession, and go down charges amounting to rupees so and so,
yes,
must be cleared in full within 7 days from the date of this letter. If you do not respond to the notice and clear the dues before the above mentioned period, the bank shall deem it has your consent for disposing the vehicle towards clearing your liability. The sale proceeds shall commence at the bank's convenience and discretion. The payments received by the bank through the sale procedure shall be applied towards the whole of the outstanding of your loan amount. You shall still be liable for any remaining dues and be obliged to clear the balance if any. Please note that if the amount received from the sale of the said vehicle is in excess of the amount outstanding under the loan, together with the charges and interest thereon, the balance, if any, shall be forthwith handed over to you. Then Lordship is the post-sale notice, which is at page 34. And after getting this notice, my lord, he rushes to the court. Despite
6th of
our
January.
yes,
6th of January you issued the notice.
yes, post-sale
Within
notice.
7.
This has mentioned in his complaint also that he has received this notice. neglected to pay the whole of the amount pursuant to the rights vested in us under the loan agreement. We have sold the vehicle for which the said loan was availed by you and which was repossessed by us on your committing default in the repayment of the agreed installments as aforesaid. We wish to inform you that after adjusting the sale proceeds less expenses against the amount outstanding against the said loan, amount of so and so is payable by the customer. After this, my lord, this FIR is being registered. Now, my lord, my point is, my lord, this repossession and sale of a vehicle by the financer due to default committed by a borrower, admitted default committed by a borrower, by no stretch of imagination constitutes any criminal offense. It might be a civil wrong which is to be adjudicated in arbitration proceedings, but it cannot constitute a civil wrong, or any criminal proceedings can ensue from such repossession and sale of the vehicle. In this regard, my lord, I would.
What is the offense alleged against you?
My lord, offense is 323, 356, 379, 327, 34 IPC. My lord, initially the case was registered with Beliaghata police station. Thereafter, due to jurisdictional issues, it was transferred to Fulbagan police station. A fresh FIR number was given and the sections were also altered. So sections are 323, 356, 382, 379,
323,
323, 356. Eta no, major acta no. 382. 379, this is the main section, theft of vehicle. 327, mischief. 34, IPC.
Okay.
Now, may I just hand over this compilation to your lordship? Since 1979, this has been the consistent view of the Honorable Apex Court that repossession due to default does not constitute any criminal offense. Because, my lord, all these agreements are in the nature of hire purchase agreement.
Correct.
My lord, in hire purchase agreement, my lord, the ownership remains with the bank. The hirer takes the vehicle on rent. He pays the loan agreements. And the difference between a loan and the hire purchase is this. That in hire purchase, my lord, the hirer has the option to become the owner of the vehicle upon fulfilling the terms of the agreement. That is upon liquidating the entire loan amount, which has not been done. So it is our vehicle, we have taken back. That does not constitute any offense. My lord, kindly take the first judgment. Is 1979.
How much time you will take? It will take time.
My lord, take time.
2 p.m. is matter. Let us see if it is concluded.
Lord, next Friday, kindly makes it HDFC Bank, my lord, kindly makes it part third.
Counsel for the petition argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 28 now.
The direction given upon state, my lord, to produce the case diary, my lord. On next,
Yes, you
my
can the case diary. The
May I request
state
one?
is directed to produce the case diary at the time of hearing, on the date fixed.
Your Lordship, may I request one thing? Instead of next week, Your Lordship, if it can be possible of the
Why?
after 29th,
Let
Your
me
Lordship.
hear the matter. If required, I will address.
Your Lordship, only one difficulty is that I'm contesting in the election of the High Court Club for the.
No
So
problem.
that's why
Contest
only, matlab, we are little bit
No
busy.
problem. I will not pass any order. If any difficulty, junior will be there. I will adjourn the matter. Let he complete.
Your Lordship, I'm deeply obliged. I will try my best to be here, Your Lordship.
Come on that day. Not problem. Yes.
Much obliged.
No problem. Because it was going on. You will not. How many days?
He cannot take recourse to the vendors of the king. Moreover, he is required to explain
Each and every day.
no within the period of limitation.
Correct.
That will take respect to deficiencies in that application. satisfy your lordship. We intend to use a opposition. Your
How
lordship,
soon you will file affidavit?
1 week.
At the
No, that required some amendment. A legal position. We had used one, we had served them.
You file the affidavit.
No, well, we had not raised them. Was only supplied to the.
Not filed in the court.
So we'll be just amending it in view of the changed circumstances and we'll be supplying it by Monday.
The council for the you are appearing for
Private
opposite party, private opposite party, raised for time to file affidavit in opposition in connection with CRAN number 1 of 2020.
Initially it had another number.
CRAN number. There are two CRAN. One is 2, one is 3.
So two has been disposed of.
3 of 2022.
So CRAN 1.
3 of 2022.
He is also disposed of.
So one is not there. Item number 7. Acha, 1 of 2009. 1 of 2009. Let affidavit in opposition be filed after serving the copy to the London Consul for the petition within a week. You file reply. Understood? Let
If you're accepting it, what can I do?
let the matter appear on 5th.
বাবা তুই যা ইচ্ছে বল এবারে ভাই অ্যাডমিটটা করতে
For the statement.
Yes.
May I please, Lordship? But this relates to the quasi-criminal proceeding under section 306, section 306. Yes.
Hello. State was asked to intimate about the stage of the case. I have the case diary with me, but this final report was filed in the form of mistake of fact in the year 2000. Thereafter, they had challenged that proceeding, and that is the impugned order herein, along with questions.
Who is the petitioner?
My lord, they. But I do not
Who
have.
are you? You are the de facto.
No.
I'm about the petition.
You are the
I'm the petitioner. He is
Yeah,
appearing for the
accused.
state.
Petitioner accused.
Yes.
Petitioner accused. So they have filed the final report by mistake of file.
Subsequently, again, the de facto complainant filed in the court below for reinvestigation, and cognizance was taken under 306 and warrant was issued. That was in the year 2001. My lord, I do not have the current status of the case.
Yes,
What I have is only the
Sorry.
case diary. I've intimated them. They could not give me any trace of this case.
Okay. May I
Then
take
now you may proceed.
But may I tell you, Lordship, the facts of the case first? But this is a case that had the petitioners are facing the prosecution for the last 36 years. For the last 36 years, it was initiated in the year 1989. Now, this is 2025.
1989 FIR chalked out.
And
FIR has been-
yes.
And when the first report was filed?
Well, this was filed
when the first report was filed with regard to the mistake of fact?
Just a minute. On January 2, 1990.
1990.
Yes.
Okay. Then
my lord,
reinvestigation was carried out.
Then
Then charge
there
sheet
is a
filed.
final report.
Final report or charge sheet?
Second, no.
Second also FR.
PFR.
Re-FR. Then the court taken cognizance.
31st March 91. Second one.
31st March 1994.
94.
Yes. 91. 94. 94. And the third one on January 31st, 2000.
2000.
As there is no materials to connect the petitioners with the alleged offense.
Where is that?
Well, I have written it in the petition itself.
Now, where is the document? Have you annexed?
Have a look at my list of this.
Okay, I will take.
দাঁড়া এবার তুমি বলো না আপনার একটা কমপ্লিট তাই ও আচ্ছা আচ্ছা On the third final report, the court took cognizance under section 306 of the Indian Penal Code without any materials or record.
Where is that's why I'm asking, where is the third final report?
Yes. Have a look at it. Page 15 is the third final report.
Okay.
The third one was mistake of fact. Thereafter, they had filed. Third one was 2000. First 1990, then 91 October. The last one, the year 2000.
That's why last one is
2000. Thereafter, the de facto went down to file another Narazi petition. Whatever, then the cognizance was taken. That is the impugned order here.
Second.
See, last petition, 2023.
I think. Look at the first FIR at page 10. Final report at page 10 of my application. Page 10 of my application.
Yes.
Now the second is not with us. The third is at page 15.
Yes, the third I have gone through.
Yes. Now, my lord, your lordship will find it from the records itself that here is a reverse case where the husband had committed suicide. Now, my lord,
You made a party. Who are the parties? State and?
the parties are, my lord, I am telling your lordship, the petitioner number 1, Sunil alias Batshagiri, is a neighbor.
No, you are the accused persons.
Yes.
Now, who are the private?
Complaint was also made a party.
Respondent number 2.
Yes.
Notice served.
Yes, everything is.
Anybody appeared before?
No, nobody has appeared.
Nobody has appeared. Yes.
Now, my lord, number 1 is the neighbor.
Hmm.
I will look at the list I have given to your lordship. Number 2, my lord, is the wife of the deceased Gauri Manna. Number 3 is the father-in-law, expired. Number 4, my lord, is the brother-in-law of Gauri. Number 5 is wife of number 3. Wife of number 3. That is mother-in-law of Gauri. Now that from the very beginning, you will find it that there is an omnibus allegations for torture.
How the deceased died?
But she died by hanging.
By hanging.
By hanging. But there is suspicion that there is extramarital affairs with the deceased Gauri Manna with somebody else, with the wife of the deceased Gauri Manna, and therefore, my lord. But throughout the FIR and the connected paper which you have got from the final report itself, that there is no whisper anywhere. And what is the part played by the petitioners? And omnibus allegations throughout, all through.
That's why I'm telling where is the cognizance. You are telling the cognizance.
Page 23 of the
Petition.
page 20.
What? What?
15 to 19 on 16/6. Page number 2, page 24. The learned magistrate who has taken this cognizance. Who has taken the cognizance? Who has passed this cognizance order?
Oh, who has?
Which court?
Yes, my lord. By passed by the learned sub-divisional judicial magistrate Contai.
Subdivision magistrate.
Yes. Yes, ordered.
How the subdivision magistrate?
Have a look at my constitutional of the petition.
Subdivision judicial magistrate.
Yes. 30th of January 2001.
SDJM.
Yes, SDJ. At
SDJ.
that point of time, there are SDJ.
Yes,
Later on, it has changed to
So
SDJ.
where is that document? Are you in page number 15 to 19? Which document? Have you gone through page 24?
On my application.
Your application page 24 is the impugned order.
Yes.
As per the impugned order, the London magistrate has gone through the report of the gone through the page number 15 to 19. On
third FIR.
It's on 61 statements as put under 61.
So this is the original CD.
Mine.
15 to 16. 15 to 19. 15 to 19.
Now the allegation is that the AP was having illicit affairs with this petitioner. The husband objected to it on the relevant date of incident. She wanted to go to visit a show. The husband objected. Thereafter, these persons assaulted. The allegation is that he came and he committed suicide. Postmortem is at page 52. This is
Postmortem, if the suicide one, nothing can be done. But only the London magistrate is 15 to 19.
Yes.
Then 21 to 24.
These are the statements. All
So you do one thing. You give me the translated copy. That is the only thing whether that document, that statement contains any cognizable case or not.
No, my lord. The contents in my subject to correction. I have lost it. Whether the statements make out any case under section 306 as contemplated under section 107.
That is different.
Yes.
First, you come to the page 24.
Of course.
The London magistrate has considered these statements and find that the prima facie case is made out and cognizance taken.
Of course.
And issued some warrant. I don't know why the warrant is issued.
He
I don't know.
in position to say what happened after that. We have no.
What has happened to this warrant?
Kothai? Abar ki hol? Nothing.
We do not.
Nothing.
No, the magistrate has passed an order for warrant. What has happened? Is there any stay of the warrant?
No stay because this revision was filed in the year 2001. The first order speaks of that. They wanted an early hearing.
So you do one thing, madam. This is your CD. You get the translated copy of page 15 to 19. All the it is better. How soon you can give?
I need some time, at least a week's time.
Let this translated copy of the statement. That is the main only because this court has to consider this only.
Very
Nothing
good.
else. Sitting in the regional jurisdiction.
একই করিস না নেক্সট ফ্রাইডে আমি থাকবো না
10 days আপনি যখন
আরে সামনে বুধবার করে দেন না
translated copy of এতগুলো
কত কোনো
There are many statements.
হ্যাঁ
At least 15 to 20 statements. Need some time.
The petitioners who filed the present divisional application challenging the order of cognizance
নেক্সট উইকে হবে না
14
নেক্সট উইকে হবে না
20
আরে 28 তারিখের পর কি ডেট
and dated 3rd January 2000. 3rd January 2001. In GR case number 508 of 89, arising out of Contai PS case number 180 by 89 dated 16/6/1889, 1989, under section 302 of the IPS. This could find that the London magistrate, even after the submission of the final report by the investigating agency, has taken the cognizance relying upon the statements as mentioned in paragraph 24 of the presented. The London Council appearing for the state is directed to provide the translated copy of the statements of the witness recorded by the investigating officer during the investigation. Let the same be filed within 2 weeks. Within 2 weeks after serving the copy to the London.
Can you fix a date so that
serving the copy to the London Council for the petitioner. This is the matter on Translated copy tomorrow, they will say what it is not corrected, corrected, translated. On 12th December. 12th December.
Very
Yeah, 12th December to
at the top, make it at the top.
2 m.
I'll try to get the status also what happened to the. I'll do.
12 December.
2 p.m.
Great.
12th December 2 p.m.
At the top.
2 p.m.
Sir, 2
Very
p.m.
good.
fix.
Very good. Appearance they keep correcting now. But for the state, a man for the
I'm led by Learned Public Prosecutor.
Thank you. The CD deleted kori den oita. Ha. Call down. 62 also. Acha, supplementary. ए इसको फाइल में रखो. ठीक है. फिर भी ये भी 2 p.m. है. 2 p.m. हो गया.
Only to see compliance, my lord, of payment.
उसको फाइल में रखो. Yes.
My lord, 16 lakhs and odd was to be paid. Now, my lord, yesterday my client could arrange for 11 lakhs and odd, my lord. 5 lakhs is due. I was praying
Electric
for.
connection disconnect or no?
No,
No, lordship prevented us from doing that
kindly give us
because
some more time, my lord. We are making payment, my lord, regularly. So far as the current dues are concerned, there is no dispute about that. This is, my lord, the positive. He will not be Shylock, I know.
my lord, I am my lord, representing the authority. I just indicate
I
my lord,
don't-
my instructions and I
Proof of payment of the
I
11
don't
lakh
have
50,000.
my lord
And you will
kindly
pay the further 5 lakhs.
My lord, my instruction is 7 days, my lord.
7 days?
Yes.
7 days will pay. So I am fixing up to 7 days.
Yes,
Very good.
kindly.
Today we are on 21st.
21st.
Shylock was not allowed to speak also, my lord.
Huh?
Shylock not allowed to speak.
21. Then I am fixing on 28.
Lordship.
Very well.
No, I am fixing on 1st. Learned counsel for the petition submitted.
May I only pray for this? In the event they fail to pay by this time, kindly, my lord, permits us to, my lord, take steps for disconnection. Because otherwise, my lord, this will continue.
On first, I will decide.
Very.
The counsel for the petition informed this court that
No,
though the
okay,
petition
okay,
was not in a position to manage an amount of rupees 16 lakhs, but has only paid rupees 11 lakhs, and he will pay the balance amount within a week from date. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 1st of December. 1st of December. कोई टाइम है क्या? 1st of December फिक्स है क्या? तो 1st of December at 12 noon. 12 at 12 noon. 12 भी फिक्स है? फिक्स 1 बजे करो 1 p.m.
On 1st.
On
Yes.
1st December.
First.
Who's for the petitioner? The administration is directed to the officer in charge of the document is to be present before this court on the next date. Who are appearing for the state? Anybody is appearing for the state?
My lord, Mr. Abhishek Sinha, my lord, on earlier occasion, my lord, appear for the state, my lord. I'll inform him, my lord.
No, but there is a direction, the officer in charge of the Damdam police station to appear along with the case diary.
Oh, my lord.
In the order dated, that is 2024. I don't know what has happened. Despite of the giving considerable period of time, the trace of the case record of GR custom officer.
Next date, my lord, it will be.
Time passing an order.
My lord.
By an order dated 22nd April 2024, this court directed the officer in charge Damdam police station to submit report why the record of GR case number 4238 of 2009 is not traced out. In spite of the specific direction, no report has been submitted. Accordingly, the registrar administration within bracket L and OM is directed to accordingly, the officer in charge Damdam police station is directed to appear before this court on the next date of hearing with an explanation along with the case diary. Let the matter appear on 28
as well.
28 November 2025.
Keep living.
In the earlier days, on the 7th of this month, the matter was hard on length, and your lordship has already gone through the impugned order and both the trial court's order. Against the judgment of the acquittal, they have prepared this revision. We got acquitted in the magistrate court. Against that, they filed an appeal before the session judge. That is also the accused got acquitted. Against that, they came up with a revisional
Where is
application.
the petitioners?
Petitioners is now disappearing. Well, somehow, my lord, I am been entangled with this from 2012, and even after that, it is held by both the court. There is a frivolous and false litigations conducted by the complainant, and unnecessary trouble has been given to them. One of the accused number earlier days I submitted accused to the opposite party number 2. He expired. One is his son. Unnecessary legal implication, false implication with this case, my lord. And the matter is
But the other side is not here.
No, to somehow they are trying to entangle me and they are delaying over this matter. My lord, I will humbly pray before your lordship, my lord, so far the record is concerned, my lord. This is a case liable to be dismissed, my lord, with cost. Very frivolous litigation. Otherwise, I could not have made any submission.
Yes. What is the contention?
Contention is that, my lord, kindly record the impugned order, my lord. Kindly see the trial court's order. It will be self-explanatory. I will not go through the entire order, very lengthy order, but it is order is, my lord, written with recording all the evidences. My lord, kindly see the annexure, page number 44, the judgment of the trial court. Judgment of the trial court. Only in nutshell, I am giving some hint, my lord. May I just submit, my lord? In nutshell, the primary case is that it was against the delivery of the materials. They claim that they are entitled to recover certain amounts. They say that we did not pay. That is why they obtained an ex parte order from the civil court, civil court. Thereafter, one simultaneous case was filed. I filed one judgment in the earlier days.
In that case, that was a check bounce case connected with this branch of transactions. Only 24,000 of amount was involved in the case, and we gave a check. Check was dishonored. By suppression of the entire thing, they have filed with the false and fictitious bills and vouchers, everything, all genuine documents. They called for the expert. Even the handwriting in the bill does not appear as a matching signature. Handwriting expert was called at their instance. They did not exhibit the handwriting. Such being the situation. Mainly on the ground of suppression of the 138 case was there against the dishonor of the check. Against that check, one complaint case was also registered. That was also, we are convicted in the 138 case. We paid the entire amount of the check amount. Even thereafter, they preferred a revision before the appellate court and thereafter they came up with the honorable court, and the honorable court has also found that only they have enhanced the amount of compensation in that case. This is the background of this case. Now, my lord, kindly take up the page, my lord, 45. I am reading from page 45. May I just read, my lord? Page 45. At the time of argument, learned lawyer of the complainant argued for cheating by false representation without delivery is an offence within the ambit of the offence under 417, but when
Not necessary.
not necessary. Then kindly, my lord, come to only one thing, the first paragraph, that there is another complaint case C3759. This case was filed by this petitioner against us. This complaint case, they have suppressed the whole thing regarding the bouncing of the check and this case, and they continued these people. Then the next paragraph, my lord. Let us scan the documents on record. As I have already mentioned that Exhibit 1 are the tax invoices and delivery receipts swear upon. Exhibit 1 by 1 is the signature of the accused number 1 on the receipt copy dated so and so. Exhibit 1 by 2 is the signature on the receipt copy dated so and so. At the time of admission of this Exhibit 1 by 1, the defense raised objection, and it was noted both in the evidence as well as it is seen from the Exhibit 1 by 2. Apart from the defense on the document itself, it is also evident from Exhibit 1 by that there is no rubber stamp of the accused company. As it is seen from Exhibit 1 by 2, apart from this former one bears no date with the signature of the accused number 1, whereas the later one bears the date. Exhibit shows bears read commercial sales tax number so and so, CST. It is clear that the complainant is or was a payee of the commercial tax. The only case of the complainant is that the accused has received so-called goods by putting his signature on receipt copy and did not pay the amount and finally denied the whole transaction. He or they cheated complainant. So it is the genesis of the case whether the signature bears Exhibit 1 by 1 is of the accused when number 1, when defense is raised objection against this document. I think it is or was within the well knowledge of the complainant, and that being so, the said document was sent for the expert because of the disability in the document, expert for decision, and finally their report was reached, but the report is kept intact, and surprisingly no initiative was taken on the behalf of the prosecution to bring this document. Next page, my lord. First of all, it was required for the expert opinion, and opinion expert report was not exhibited. Now, my lord, leaving few paragraphs, leaving few lines 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 15, leaving 15 paragraphs from the top. Now, this page is very crucial. Now, the story of issuing the check and its alleged dishonor is totally a foreign in this case, as nowhere in the petition nor in the evidence PW1 it has been stated. But at the first time it came, at the time of the cross-examination of the PW1 and in the argument of the complainant, reasons for such successive delivery without any payment as placed by the learned lawyer for the complaint is too hard to swallow, where the complainant himself imposed stringent condition for the alleged transaction, where the instant payment on delivery was basis for the transaction. According to the complainant, he made the first delivery on 24th of April 2005, second one on 20th of May 2005, simply on the promise that the accused person to make the payment. The amount of the first delivery and the second are respectively of rupees 17,000 and 15,000 and odd. The argument advanced for the delivery by the learned lawyer is an accused is as an accused made over a check of rupees, check dated 29th of 2006.
Yes.
So they disbelieve the entire thing when you are not paid. You are not paid. How can you? Next paragraph is next paragraph. What was the amount of the good allegedly delivered the third time? Here, case starts with the lot of doubt. It was for the rupees 1,24,000, near about 8 times for the first delivery, whereas the alleged second delivery was 2,000, less than the alleged first one. The first two deliveries of the materials only amounted to rupees 24,000, 15 and 10, and thereafter, these gentlemen tried to increase the amount by fictitious documents and bills, 1,24,000. The learned magistrate observed that when you are not paid, what prompted you to make a delivery after 1 year without any payment, and you have suppressed the entire story of the author. What was the amount of the goods allegedly delivered? Third time it was for the rupees 1, near about. The complainant, as it is evident from the evidence on record, a payee of the commercial sector is not a layman. As such, there is no reason to believe that he allowed accused to receive such huge quantity of materials at the third time on presentation of a check of the rupees 24,000 on condition the present check for encashment after third delivery. That he delivered with the assurance that this check will be cleared. Thereafter, I will show your lordships that after 1 year, the third delivery, according to the complaint case, was made by the complainant. The check, as stated by the learned lawyer in his written argument, was issued by the accused number 1 on so and so. When argument so and so, where the present case was filed on 9th of February. So when the check was issued on in the year 2006, when they have filed the complaint case in 2007, they have suppressed the whole thing and filed one complaint case, C case number 3759.
Yes.
I have already mentioned that nowhere in the petition it was stated that PW1 delivered the goods for the third time as accused, made over a check to him. This is the suppression. They have not stated anything in the complaint that this was the check was issued, it was dishonored, and I will show 2-3 lines from the examination of the accused persons or the complainant cross-examination reveal the whole thing.
Okay, come on the next. The other side is not there. I am fixing on next week.
My lord, kindly give any date, my lord.
28.
28, my lord, on the top, my lord. There, my lord, unless
None appears on behalf of the petitioner.
Okay, the
And counsel for the
Lord, instead of 28th, can it be, my lord?
party number 1 and 2 has argued the matter. Argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on
My lord, really give me one. 5th.
5th December 2020.
Gratefully, Lord. Great.
Yes.
Gratefully.
Lord, may I please your lordship? My lord, the petitioner is a charitable trust. The petitioner, my lord, is also managing various affairs, my lord, religious affairs. My lord, these affairs petitioner is conducting for a considerable length of time. On the last occasion also, last year also, my lord, the petitioner has applied for the permission before the respondent number 2 for holding the, my lord, the religious
What religious
functions, and also, my lord,
What are the religious functions?
religious function, my lord, that is the features the Bhagavad Gita, and also, my lord, there are other devotional songs, and also, my lord, chanting of the Vedas and other religious activities.
Where is the program of
The program has been fixed on 23rd.
Now, where is the chart of the program? Which date? What?
Yes, my lord, that your lordship will appear. Kindly come to page 39, 38 onwards.
38.
38, yes. Annexure P5. Written in Bengali, your lordship will find the entire details.
That's long translated copy.
23rd to 3rd December, I think. 23rd
December.
November to 3rd December. Sir, we have accorded permission. My learned friend need not go into all these things. Yesterday it has been passed to the secretary who has affirmed the petition, but we could not locate him yesterday. Otherwise, we have communicated yesterday itself.
Thank you.
I got in touch with the SDO. It was already issued in the office. all other permissions they have already got, my lord. We have given a provisional permission. Let them go ahead with it, my lord.
Have you got this?
I have given him a copy.
Just now, my lord, it was sent.
No, I am disposing.
Yes, yes.
Now your lord.
The petitioner has filed the present writ application for direction upon the respondent number 2 to grant necessary permission to hold the annual religious program commencing from 23rd November 2025 to 3rd December 2025 upon compliance of all formalities. When the matter is taken up for hearing, learned counsel appearing for the respondent state here for the state has handed over the order dated 19/11/2025, wherein the sub-district officer Bardhaman for the North Bardhaman has granted permission to the petitioner with effect from 3rd November 2025 in view of as the authorities already granted permission to the petitioner, nothing remains in the present application. The writ petition is disposed of. The order dated 19/11/2025.
But only one indulgence I would be seeking. My lord, the police authority also made a party here. But they
have already given permission recorded in the first line of that order.
only one line. They will render necessary assistance.
But this is not for police assistance. The writ is for direction upon SD.
Already there.
Kindly, if you lordship add one line for just to
What you want? What?
police authority, and because I have to manage the whole affair.
See,
That's why.
I hope he is not apprehending any law and order issue
So,
with his
the authorities already granted permission to the petitioner,
all
but the local
will
police
extend-
authorities are directed to see the
আবার সোমবার মামলা করবে ভালো হতো
see the peace, to keep the to keep the to see the law and order should be maintained. So
Grateful to you, lordship.
yes. Who is for the petitioner? You are appearing? No.
Well, I have for the state, my lord. In all those matter whose states not appear, my lord, I am here, my lord, posted by the PP office, my lord. And my difficulty is, my lord, if my lord the petition is, my lord, with me, my lord, I will do the matter, my lord. The most
That's
of
not
the
the
cases,
problem,
yes, my lord.
appearing.
Your lordship is absolutely right, my lord. But most of the cases, my lord, petitioner is not here. At the old matter, I am trying to, my lord, recollect the case diary or as well as my lord.
Seeing of the
petition.
proceeding under the case.
I think, my lord, 24, 5 and 6, my lord, all three are, my lord, the same matter. Connected, related matter, my lord.
Three 376.
Washing. Then, my lord, it's required to, my lord, the
Providence.
case diary is required, my lord. Lordship,
As none appears on behalf of the petitioner, the state is directed to produce the case diary on the next date fix. Let the matter appear on 19th December.
19th December. Kindly permit me, my lord, to take down, my lord, the
Yes. The learned counsel for the state is given liberty to take down the relevant case FIR number of the concerned police station so that on the next date fix, the case diary can be produced before this court by the investigator. Next.
Lordship, item 25, I am led by Mr. Sarjati Dotto, Lordship. Lordship, we don't have any copy of the petition, and we have been engaged by High Court legal aid. Therefore, Lordship, I am praying that if your Lordship kindly direct the High Court legal aid to serve a copy upon us, so that we may appear.
By which order you have been appointed by legal aid?
Lordship, that I don't have the
Have you received the communication from the legal aid?
Lordship, yes, Mr. Dotto has received the communication, but Lordship, at present we don't have the.
আমাকে 24-এর এটা একটু দেবেন, হ্যাঁ?
Sarjati Dotto?
একটু
Yes,
দেখেন,
yes,
ঠিকঠাক
Lordship,
মতো।
yes.
অর্ডার হয়েছে।
What happened? So,
আমি এদিকে বসে আছি, তুমি যেতে পারো, সব ম্যাটারই আছে 24 এটা। অর্ডার
and for the state, who is appearing? Sandeep Chakravarti.
My lord.
You are
He's-
appearing.
No, I am not Sandeep Chakravarti, my lord. He is the. I am appearing, my lord, on behalf of him.
Appearing. But as per the order, Sandeep Chakravarti.
Yes, yes, my lord. Sandeep Chakravarti will appear, my lord. I will inform him, my lord. He is, my lord, in the matter just after, my lord, before, my lord, the recess, my lord, he is here, my lord. He is in court number 35, my lord.
Record an order.
24
By an order dated 9/9/2021, this court.
25
directed Mr. Sarjati Dotto to represent the petitioner, who is the legal petitioner. The learned counsel appearing for the petitioner submitted, though this court has appointed from the legal aid panel advocate, but the copy of the petition and the documents is not provided. Accordingly, the department is directed to provide the copy of the application and the connected documents to the learned advocate appearing for the petition who has been appointed from the legal aid panel within a week from date. This is the matter on 12th December.
Grateful.
Give. लोअर कोर्ट रिकॉर्ड अच्छी की लोअर कोर्ट रिकॉर्ड है लोअर कोर्ट रिकॉर्ड है record. This court finds that the present revisional application is pending since the year 2012, but for the last several dates, none appearing on behalf of either of the parties. The lower court record is already available on file, CAV. Next.
Made please, Lordship. Lord, I am appearing for the petitioner. I am being led by Mr. Jantana Chatterjee. Lord, the petition has been filed praying for quashing of the entire proceedings and the rejection of my prayer for discharge.
What is the section against you?
Lord, the section
What is
has
the
been.
offense?
Lord, the offense, Lord, the petitioner is the divisional
380/506.
380 and my lord 156(3) was initially lodged, and thereafter the sections which have been given is 323 and 380 of the IPC. The petitioner is, my lord, the divisional engineer of West Bengal State Electricity Distribution Company Limited. Now, my lord, an inquiry was made and he found out that the meter given by the board was tampered. Now, when they went there to make the inquiry, subsequently a complaint was lodged for theft in the dwelling house and for causing, my lord, hurt. Now, my lord, without sanction, the proceeding was initiated and the charge sheet was also laid. And thereafter, I made the prayer for discharge, which was rejected. Against that, we have filed this revisional application.
In this matter, my lord, learned state advocate, my lord, who was appearing, my lord, on earlier occasion, he has died, my lord.
You appeared, I am regularizing your appointment.
My lord, if your lordship is kind enough, my lord, kindly direct them, my lord, to serve a copy, my lord. I will, my lord, take entire thing, my lord. Entire
What is the
case
good name?
diary. My lord, Arindam Sen, my lord.
Record and order. It is informed that the learned advocate who is appearing for the estate passed away. Accordingly, Mr. Arindam Sen, who is appearing for the estate, is directed to appear in the matter, and the state is directed to regularize the appointment in the present case. You are having the copy of the petition and documents.
Today itself, I shall hand over.
The petition is directed to serve the copy of the petition and the connected documents to the learned counsel for the Mr. Sen by tomorrow. List the matter on 28th.
28th, my.
I'm grateful.
For item number 28, madam, led by Mr. Shontipan Ganguly. Well, if your lordship kindly fix it on Wednesday. This matter was
Only I am taking on Friday, criminal matter.
well, kindly fix it on Friday, my next Friday.
28th.
Welcome. Obliged, my lord.
Fix on 28th. Next.
Lordship, I'm for the petitioner, Lordship. Lordship, I've prayed for quashing of this application on the previous occasion. Your Lordship had directed for a report from the lower court. Your Lordship, there are similar matters which have been quashed. I would like to for the orders. Your Lordship, there are two similar proceedings, CRR 123 of 2012 and CRR 1666 of 2012. Both have been quashed. Lordship, this is a
They connected the same FIR.
Lordship, these are complaint cases.
The complaint case.
Yes, Lordship.
No,
Fantastic.
you're giving this document how is connected. This
Your Lordship, the petitioners are the same. It's pertaining to the same company which has been liquidated.
Who is the petitioner are the same?
Yes, petitioners are the same.
And this is a state case.
Yes, Your
The
Lordship.
state case.
Yes, Your Lordship.
And this is a complaint case.
Both are complaint cases.
Both
Your
are
Lordship.
complaint case.
Both are
No,
complaint.
This one also complaint case.
Yes, Your Lordship. Both are 138 cases, Your Lordship. Both are 138 cases, Your Lordship.
130.
Yes, Your Lordship.
Yes. Which for the other side?
On the previous occasion also, the OP2 was directed to personally appear, but today also no one has appeared.
Yes, what is the case about?
The Lordship, it's regarding a 5 lakhs amount check which was dishonored. The Lordship, there is
complaint. Where is the complaint?
Yes, Your Lordship. The complaint. The Lordship, it's just after page 37. The original certified copy of the complaint has been annexed.
Who is the complainant? Sweta Singh.
Sweta Singh, yeah.
And you are?
The Lordship, I'm for petition number 2 and petition number 4.
Rekha Malhotra. 4. And Pradeep Kumar Malhotra. 2. And Mohi. This
I apologize, Your Lordship. I'm for all the petitions.
Yes, all are.
Yes, Your Lordship.
So why the Samsung? Why the Samsung expert has been made party here?
Your Lordship, they had
neither it's not the accused here.
No, Your Lordship, the problem is they had some grievances regarding getting that amount. The problem is we have provided that check which was dishonored, which was a security check.
No. Kindly come to your complaint.
Yes.
In the complaint case.
Yes, Your Lordship.
The certified copy.
Yes, Your
First
Lordship.
title.
Yes.
First title. Shweta Singhani is the complainant.
Yes, Your Lordship.
And all are for. So where is that accused number 1? The company's party.
Yes, sir. Lordship, company has been MS Sumoson Exports.
Where is in party in the present application? Present division application.
Lordship, that company has been liquidated. That's why it has no longer been made a party.
Okay.
Lordship, it has been wounded up on 30/8/2011.
By the order of the company court.
Yes, Your Lordship. Companies CP 363 of 2009.
Yes. Here is a complaint. This is a complaint.
With your Lordship, please, may I submit? This is a proceeding under the 138 Negotiable Instrument Act. The Lordship, the complaint, Lordship will find at the certified copies.
Yes, I am there.
Lordship has seen the complaint. May I just show your Lordship two things between the same parties. There was proceeding pending, and the Honorable Court was pleased to quash it on essentially on 2 grounds. One, so far the petitioner number 2 is concerned, she was a director, and prior to issuance of the check, she resigned. So, Lordship knows that Form 32 was filed, and prior to the cause of action, even the check was issued, she resigned. And so far the petition number 1 was concerned, Lordship knows, Lordship will see the complaint, that there is not a single averment that he was in charge of the company, and he was.
Petition number 2 is. Who is the petition number 2?
The petitioner number 2 is Pradeep Malhotra, and 1 is Rekha Malhotra.
No, petition number 2 is accused number. Petition number 2.
Petition number 2 is Pradeep Kumar Malhotra.
Pradeep Kumar Malhotra.
Yes,
Yes, he is the director.
He was the director, but Lordship has seen the complaint where there is no averment that he was in charge of the day-to-day affairs of the company, which is essential in terms of section 141.
Okay, there is no averment with regard to the 2.
Yes, and 1 is the director, who has resigned prior to issuance of check.
When resigned?
1 and 4. Lordship, the check
2/3/2010.
The check is dated 15th of March 2011, and I have resigned from the company on
2nd of March.
2nd March 2011.
2010.
2010. I'm sorry, 2010.
March 2010.
Page number 36 is my Form 32. Lordship will see that my date of resignation is 2nd of March 2010.
Page 36.
Page 32.
The resignation letter.
Yes. 32. 32. I'm sorry, 32. Lordship will see.
36.
32.
32. Lordship kindly comes to page number 32. At the bottom portion, Lordship will see. First, Lordship sees the name.
Page 32.
Page 32, next to B, Lordship, it's a Form 32,
Rekha Malhotra.
Yes, Rekha Malhotra, and Lordship sees absolutely at the bottom, with effect from 2nd March 2010.
Yes.
And the check, is impugned check. Lordship will see the complaint,
This is with regard to the accused number 4.
Accused number 1,
Rekha Malhotra.
Rekha Malhotra, 1.
Rekha Malhotra, that's interesting. You come to the.
Yes, accused number 4, Yes, I'm sorry, petitioner number 1, accused number 4. I'm grateful, 1 and accused number 4 and 5, are the 2 directors who had resigned prior to issuance of check, From the petition of complaint, 4 and 5 are 2 directors who had resigned prior to issuance.
So this is 4. 4 is resigned. The Rekha is resigned.
Yes,
2nd March 2010.
Yes, my lord.
Correct.
Yes, my
That
lord.
is page 32.
Yes, my lord.
And Mohit, where is the Mohit document?
And my lord, so far the other director is concerned, my lord, Urvashi.
Now, Mohit.
My lord.
Mohit.
Mohit did not resign, my lord.
Just stated that 3/3/2010.
My lord,
He has not resigned.
Rekha and Urvashi resigned, my lord.
Urvashi resigned.
My lord, page 33, lordship sees.
Page 33. Yes.
My lord, lordship sees the name, my lord. And my lord sees the date of effect.
Yes.
So my lord, these are all prior to issuance of check.
Correct.
And my lord, so far the accused number my lord, 1 and 2 are concerned, my lord. My lord, 2 and 3 are concerned, my lord. Sorry. But 2 and 3 are concerned, my lord. My lord, we'll see that, my lord, whether that word, my lord, which is absolutely German, my lord, in charge and responsible. Yes, my lord. In charge and responsible for the day-to-day affairs of the company, my lord, that part is missing, my lord.
Okay. No averment with regard to the 2 and 3.
Yes, my lord.
And designation of 4 and 5.
Yes, my lord.
These are the
My
questions.
lord, these are my primary grounds.
These
my
are
lord.
the same ground in the this.
Yes, my lord, and it was quashed on based on that two grounds, my lord. My lord, may I take your lordship to page number 12, para number 11 of the judgment, my lord?
Yes, in instant case.
Yes, my lord, the averments part, my lord, specific rule that is his lordship had observed. And my lord, this is not sufficient to make out a case under the provisions of 138.
Okay.
So these are my primary grounds so far this person is concerned, my lord.
That's all.
Your lordship wants to hear me, my lord. I can place judgments and all that, my lord, but I believe, my lord, the judgment of this honorable court, my lord, covers that part that
Hearing concluded, see.
I'm grateful. Well, if your lordship needs any clarification from my end, lordship,
I will put them back.
yes, lordship can put the matter on the to be mentioned, we will appear.
Thank you.
I'm grateful.
Item number 30, my lord, Mr. Abhishek Sinha is appearing, my lord. He's praying for only not today, my lord.
Item number 30?
He's praying for only not today, my lord.
Not today.
Only. Deeply village, my lord.
Give, what is this? Slow. Hey, केस डायरी है क्या इसमें? You are appearing in for the state, no?
None, my lord. Then, your lordships, my lord.
As none appears on behalf of either of the parties, no accommodation is sought for the interest of justice is adjourned. Let the matter appear on 12th December 2025. It is made clear that on the date, if none appears, appropriate order.
Next date, Calcutta. Reply will.
Yes, no. Deeply believe.
Lord, may be permitted to, my lord, mention a matter. My lord, your lordship was pleased to grant, my lord, letters of administration and had directed, my lord, that there be two sureties for 23 lakhs. My lord had directed that there was a letter was to be obtained from the bank marking lien, my lord, which we found it to be difficult. We came before your lordship. Your lordship permitted us to, my lord, give to undertakings. Now, my lord, two undertakings, your lordship affidavit of undertaking, your lordship had directed to file. My lord, those are ready. My lord, when we go with the undertakings to file before the department, my lord, they say in your lordship's order, only one, my lord, FDR is mentioned, which is why they will not accept the order undertaking. My lord, may I hand up a copy of the order passed by your lordship? My lord, in paragraph 2, it was submitted that petitioner has furnished two sureties for 23 lakhs. My lord, relying on paragraph 4, my lord, they are not accepting the other affidavit of undertaking, my lord. My lord, we have told them that in paragraph 5, your lordship had clearly mentioned two sureties to furnish undertakings.
Yes. So what has happened now?
My lord, they are relying on paragraph 4, my lord, which in which these
the sureties will furnish
yes,
their
my lord, this
undertaking, stating that they will not revoke the fixed deposit receipt number so and so in favor of the Vijay Kumar Singh.
yes, my lord. This is for 6,49,000. My lord, the total is to be 23 lakhs. So, my lord, we have prepared two separate affidavit of undertakings, my lord, exceeding 23 lakhs.
Where is the other affidavit?
My lord, I have it.
Fixed deposit. You are not mentioned. Here only one fixed deposit is mentioned. On the last date you mentioned only one fixed deposit. See, the one number is there only.
My lord, yes.
Okay, it's to be mentioned, madam.
Yes, kind of. Great.
Correction. No, correction, modification.
Deeply obliged.
Yes, call the matter.
Item number 1. What that mean?
Jittery nerves. What is going to happen? And then Mr. Sen.
So I held this reputation is not correct, but with regard to the quantum, I appointed the special referee. He will decide. Quantum. Compensation. One machinery, I have 6,100. I have passed an order. With regard to the other, because the compensation, all these things, special referee will decide. 3 months time is given, so he will decide.
One order to route application was pending also.
That what is the application?
Well, it was for we had initially claimed repair cost for chamber number 3, but we couldn't execute the entire repair.
It has disposed of.
Item number 2. With 3. This matter, your learned friends have more or less concluded their argument.
Lord, I'll just, Lord, by way of a refresher, Lord, if your Lordship permits me, I'll remind your Lordship of my, Lord, the arguments that I had made, Lord, the Lordship may remember, my lord, they are asking for, my lord, an injunction in connection with a revocation of a power of attorney. Now, my lord, there was a sale, and after the sale, my lord, there was a execution of a power of attorney, which was, my lord, cancelled. That was not the subject matter of dispute, but later on, my lord, when there was another power of attorney was cancelled, my lord, with the specific powers, my lord, which, my lord, we can say at that point of time, it was not necessarily to be executed, but it was nevertheless executed. And subsequently, my lord, the client, who is a public limited company, was lord, found it competent that should be lord, cancelled. They had it cancelled. Now, lord, that cancellation is the subject matter of challenge before your lordship to say it is their main contention is that lord, that the power of attorney that was granted to them lord, was coupled with interest. Therefore, it is irrevocable in substance. In connection with that, my lord, they took out an application to say that we cannot not rely or not on the cancel power of attorney, or they may be permitted to act on the basis of the cancel power of attorney. Now, my lord, our contention before your lordship was that, lord, when I referred to the content of the power of attorney, lord, I said that, lord, the property had been conveyed to them, lord, that was pursuant to the order of this court. And this power of attorney, lord, that I had, lord, placed before your lordship, lord, do not contain anything, lord, which confers any interest in any of the properties of my client, the company, as of today. Therefore, lord, their basic contention as to, lord, this is coupled with interest, lord, that falls flat on the face of, lord, the document. That is, lord, our sum and substance of the argument, lord, that I had made. Lord, and I ended there. Your lordship remembers. Now, Lord, Mr. Sen is to reply to him, Lord.
Yes. Well, I was leading Mr. Sen. Well, the question therefore, my lord, is I'm sorry, my lord. I'm sorry, please.
Question just
Well, the only question is, my lord, therefore, as Mr. Mukherjee put it, is, my lord, whether the power of attorney is coupled with interest. If it is coupled with interest, then, my lord, it cannot be revoked. If it is not coupled with interest, it can be revoked. Now, my lord, a power of attorney never exists, my lord, on its own. It is always a document, my lord, which appears in conjunction with some other document. And, my lord, that is how the power of attorney must be viewed. Now, the first question that must, therefore, my lord, ultimately interest your lordship is, my lord, what was the purpose for which the power of attorney was granted? Well, the power of attorney was granted in connection, my lord, with a particular, my lord, transaction. What was the transaction? The transaction clearly was a transaction, my lord, to sell an immovable property.
Correct.
Now, your lordship has been shown, my lord, two documents. Well, I will not trouble your lordship with the documents once again. Lordship has been shown two documents. One is a deed of conveyance, and one is an agreement.
Deed of conveyance, my learned friend did not rely on. We had relied upon the deed of conveyance.
Yes. Now, well, so far as the deed of conveyance is concerned, the deed of conveyance did two things. It transferred the property, well, to us, and it also transferred the chosen interest, or what we call the actionable claim, in our favor. Now, well, so far as these clauses are concerned, well, these clauses, well, I'll request Mr. Sen to, well, once again show to your lordship. Now, if your lordship finds that, my lord, the deed of conveyance, my lord, transfers not only the property but also the actionable claim, then, my lord, the question is, my lord, whether this actionable claim is, my lord, more a property which vests in me. Now, my lord, what is the actionable claim that we are talking about? We are talking about, my lord, the right to obtain, my lord, compensation on account of requisition of portions of this property that was conveyed to us. Now, my lord, here, so far as this is concerned, my lord, 2003 conveyance was succeeded by, my lord, an agreement. Now, my lord, the question that your lordships will ask is, if you have already been given the property, what was the need for an agreement subsequently? Now, my lord, so far as the agreement is concerned, my lord, there was an identity of interest, my lord, between the original, my lord, owners of the company, that is, my lord, the vendor company, and us. My lord, why was that? My lord, there were common directors in both. Now, my lord, the interest in the company, my lord, was sold. The major share of the interest in the company was sold, and, my lord, third parties came in. So, my lord, naturally, since the requisition, my lord, compensation applications were pending, my lord, on behalf of the company itself, which was the vendor company, they had to be pursued by the vendor company. For example, my lord, I am the owner of a property. I decided to sell the property to Mr. Sen. But, my lord, during, my lord, the pendency of, my lord, the sale transaction, my lord, the property is under requisition. Compensation claims have been filed. So, my lord, naturally, these compensation claims will have to be pursued in the name of the company itself, that is the vendor company. And, my lord, when today the property is, my lord, now sold, Malad, and new Malad purchasers come in, so they entered into an agreement which says that very well, the same position will obtain. You can still pursue the applications in the name of the vendor company, and in view of the conveyance which has transferred the chosen action or actionable claim in your favor, you will be entitled to the entire compensation. And it is in this connection that the power of attorney documents have been executed. Well, since I am not there physically, I request Mr. Sen to show your lordship those documents. Well, this is essentially what I understand is, my lord, Mr. Mukherjee's arguments. So if your lordship finds, my lord, that this is there, well, in that case, kindly consider this. My lord, I shall try to be before your lordship as soon as possible. In the meantime, I request Mr. Sen to, my lord, just address your lordship.
We will take our notes. We have filed a notes. The very short note. Page number of the conveyance relevant clause is already mentioned. I'll just indicate to that to your lordship. Then it will be easier for your lordship to. In the meantime, your lordship will kindly note. Yes, your lordship has got it. Kindly see paragraph 1 of that note. Yes. The deed of conveyance between Punalur and my predecessor.
Correct.
Transfer of premises 13 Nelishan Gupta Sharani along with right to claim and receive compensation in respect of portions of the said premises under acquisition. Right to claim and receive compensation in respect of the portion of the premises was also expressly transferred, page 105 to 107 of the deed of conveyance.
Yes.
I have quoted here, kindly see. Purchaser herein shall solely and exclusively be entitled to receive and appropriate the amount of compensation now pending or as may hereinafter become payable on account and in respect of the said portion in possession of the occupiers. Detailed particulars whereof are stated in part 1 of second schedule, which at present are the subject matter of the proceeding for acquisition and requisition by state government and of the said pending writ application and the proceeding thereunder. So on the date of the conveyance, I became the owner, but in the records of the government, their name is still there. So the compensation proceedings were continuing in their name.
Correct.
So the conveyance gave me the right to continue those proceedings in their name, and whenever compensation accrues to Punalur, I will be entitled to appropriate that compensation. So how do I appropriate that compensation? That procedure is given in the second agreement of 2010. If your lordship kindly sees the 2010 agreement, it is very clear.
15th May.
15th May 2010.
Yes.
Kindly see paragraph 4.
Yes.
Recital B I have quoted of that agreement. Lindsay duly purchased the said property such and such by the indenture of conveyance such and such. Then recital D. Lindsay purchased the said property from Punalur on the understanding that Lindsay shall at all material times be entitled to continue to prosecute and or defend all or any of the said litigation and proceeding thereunder, and also to receive, realize, recovery of compensation, mean profit, issues and profits on account and in respect of portion of the said property, which have been the subject matter of the litigation in the name of Punalur at its own cost. Now, yes. It will be better instead of I show your lordship that agreement itself, which has been placed by my learned friend. Lordship will see volume 2, page 186.
Yes.
Kindly come to internal page 2. First party is Punalur. Second party is Lindsay Tower, the new purchaser, which is now Calm Industries plaintiff. And kindly see, and there are the conforming parties around 15 of them.
Yes.
They were the current shareholders of Punalur when this agreement was entered into. So the current shareholders of Punalur ratified this agreement by personally signing on it.
Yes.
Including the person who has affirmed the written statement here. Now, my lord, kindly see, I have placed recital B Then recital C says, my lord, which are the writ petitions and the land acquisition cases pending in respect of the property at page 191. C. Then, my lord, kindly see recital D. Lindsay purchased the said property from Punalur by virtue of conveyance deed dated 5th April 2003, and the same on the understanding that Lindsay shall at all material times be entitled to continue to prosecute and defend all or any of the said litigation and proceeding thereunder, and also to receive, realize, recover all compensation, mean profit. So this is already in the conveyance.
Correct.
Now, my lord, E. In pursuance of the understanding aforesaid, Lindsay has so far been taking appropriate steps for realization of the compensation amount, mean profit, and also continuing to pursue and prosecute the said litigation and proceedings in respect of the portion of the property in the name of Punalur and at its own cost. Then, my lord, F. Conforming parties along with their nominees have since purchased and or acquired equity shares representing about 52.76% of the total subscribed, issued and paid up capital of Punalur, also acquired control and management of Punalur. Now, my lord, kindly come to paragraph 3. This is the main body. Punalur hereby agree that Lindsay shall at all times hereafter be entitled to continue.
Yes, that already pointed out.
Yes.
On the last
3,
page.
4. Well, now 5 your lordship will see.
5 is the one. Entitled to maintain and operate the separate bank.
Separate bank account in the name of the company for the limited purpose of receiving, realizing and encashing the amount of compensation and other amount as may be received and realized on account and respect of the said property.
Yes.
So this is in pursuance of the conveyance condition.
Correct.
Because if the money comes in their name, it will automatically go in their account. So how will I appropriate that? For that purpose, clause 5 comes in. That there will be a designated bank account. I will be made a signatory to that designated account. Then I will have control over operation and maintenance of that account. So this is the mechanism to give effect to the conveyance by which the transfer of the chosen action was also transferred.
Correct.
So the power of attorney is therefore to be read along with the transfer of interest which takes place by the conveyance, ratified by the current shareholders of Punalur by the 2010 agreement, and therefore the power of attorney is a composite document to give effect to that right, which has already been transferred by the conveyance. So in that sense, it is a power coupled with interest, because the interest I have derived from the conveyance.
So as per your contention, if we did this agreement along with the power of attorney, that coupled with the interest.
Along with the conveyance.
That's why.
Yes. Now, I will kindly see also clause 7 in this regard. 6 and 7. First is, they will give me power of attorney, empowering him to represent Punalur.
One thing, Millard, we thought we were at the stage of reply.
Why is
But
Mr.
we are going on into the merits of the matter, Millard, the facts.
Yes. No, that's why I'm telling already. I have recorded. I have.
But everything is there.
What Mr. Sen is telling already. I have taken note of.
Very well. But I will not go on that. But just kindly note, but from my note, I have also referred to paragraph 6 and 7 of the agreement, because there it says it is irrevocable. Now, the other point, my lord, which my learned friend was trying to harp upon is, my lord, the prayers in the suit and the prayers in the application are more or less identical. To that, my lord, I will just show your lordship, my lord, the reliefs. Kindly see the prayer portion of my petition.
Of GA1.
GA1. Prayer D, your lordship will consider in aid of the final prayer. This is, of course, not without prejudice to my contention, which my learned senior has argued also with the judgments, that in exceptional situation, there is no bar upon the court to grant a relief which is akin to a final relief also. And those judgments, my lord, we have already cited before your lordship. My lord, today what they are doing, they are trying to render the practically the conveyance, the agreement, everything infructuous, because their attempt through the legal process has failed. Challenging the conveyance after 13 years, challenging the agreement of 2010, all have failed because all their suits and counterclaims regarding challenging these two agreements have failed. In the city court, they have failed. So the only way to now try to get hold of the money, which they have already transferred by the conveyance, is revoke the power of attorney. But my submission is that is one not sufficient. Even otherwise, this is an exceptional situation whereby you are trying to nullify a deed occurring in 2003. So therefore, it is an exceptional situation where, if necessary, the court will pass an order akin to a final relief. It is not an impediment on the court. But I say, if your lordship considers prayer D is in aid of the final relief, and it is not a final relief. Page 30.
Yes, I am there only.
I cannot now at this stage, but kindly say their conduct, 2003 conveyance, 2010 agreement. No steps taken. I have pursued the litigation. In 2021, for the first time, there is an award money which is coming to the account. So 2021, now that the money has come, the greed has overflown, and you cancel the power of attorney. What were they doing from 2010? And this person who has affirmed every affidavit, he is the signatory to the 2010 agreement. So I say that there is an exceptional situation which has been created.
Again, the same question.
Yes,
Once this court has passed an order for stay of the proceeding, and now the GA1 will.
That your lordship.
What would be the effect of
Yes,
this way or that way?
I'll answer.
What would be the effect of that?
I'll answer that. Look, your lordship has passed an order for stay of the proceedings.
Correct.
It is not, that is stay of the proceedings. That means the suit shall not be proceeded with. That is what the appellate court has clarified, that the interlocutory application can proceed.
Correct.
And that is why your lordship is only hearing GA1 today, which is an interlocutory application.
No,
But
that's right. So now this prayer connected with. So what the submission they have made, the prayer D.
Yes.
Is the main relief of your.
No, prayer D, no. Kindly see what they have said is prayer A.
Sorry, prayer A.
Prayer A is the main relief.
Main relief which is in the prayer.
Prayer A, prayer B is in the nature of the main relief which is there in the plaint. Judgments say that an interlocutory court at interlocutory stage is not powerless to pass such relief if a case is made out. I am saying, today that case is made out because from 2010 till 2021, they have just waited in the wings for the money to come. The moment the money came, they wanted to use that money contrary to the right which they have transferred to me. That is why they took this step, drastic step of revocation of the power. And now kindly see, view this act with another act. They tried to challenge the 2010 agreement. They tried to challenge the 2003 conveyance. As of today, all those legal challenge has failed. So therefore, I am coming to that. I will not make any.
2010 document was challenged by them before the civil.
Where? What are you saying? Your counterclaim. Please don't make this submission. This is very unfortunate.
What has happened to the revision against the counterclaim? That
there is no revision. There is the first appeal.
There is the first appeal pending against rejection of the claim. Rejection of claim.
But
not decided on merit.
My lord is considering the situation as of today. When your lordship had passed that order for stay, at that time those suits were pending.
That's right.
Now there is an event that the suits have been dismissed under Order 7 Rule 11. So today that situation is no longer prevailing. And those two suits are still dismissed. My suit has been stayed because of their appeal against the rejection of counterclaim.
Yes.
Now, my lord, kindly see prayer D. prayer D does not stand in the way of any proceeding, because your lordship is hearing GA1. Your lordship can only concentrate on GA1 prayer D.
Yes.
Because at least I have made out a prima facie case today. And this is the last recourse what they are trying to now do. They are trying to say that I cannot file any proceeding in respect of the acquisition proceedings money which has already come. To get that money where then award has been declared, I have to file an execution. I have to file a stay of the proceedings under section 36. They are trying to say power of attorney revoked, you cannot file.
Yes.
Now, I will kindly see why they are saying this, because they had earlier made the same attempt before the arbitral tribunal. Before the Supreme Court also they had gone. The Supreme Court had rejected their prayer for intervention in the arbitration proceedings. So now this is the last ditch attempt by them in the executing court. They are filing the application for intervention, saying that this suit is pending, therefore they have a right of intervention. So we say, before your lordship, prayer D is the prayer. Even if your lordship grants this prayer, this will not cast any impact on the final relief of prayer A and prayer B.
Okay.
And as a plaintiff, I have to make out a prima facie case. The prima facie case of irrevocable power of attorney, which I am showing, not only from the document itself, but saying that it is only a continuation of the right transferred by the conveyance and the agreement of 2010. I think these are my submissions. But I have referred to the judgments in my notes only.
Okay, I will take care.
Yes, so we have prepared a short notes lot for my lord to produce that. Kindly permit us to file that.
Ready?
But Monday, we will give it.
আমাদের একটা কপি দিয়ে দিন
তোমাদের তো একটা কপি দিয়েছি
Hearing concluded.
And there is one judgment in connection with this matter by the division bench, wherein there is an order which says that in view of the fact we are not allowing any further release of the balance amount, the prayer made in the application is not allowed. That was on an application made by them for not taking the money which comes in the account of my client. That was in the FAT.
This order, there is a subsequent Supreme Court order.
Justice Sen's order.
Yes.
Yes.
But kindly have a look at the Supreme
Yes, thereafter it was modified to the Supreme
It was.
It is also part of my petition. But kindly have a look at the Supreme Court order. And this security has been furnished before the City Civil Court to their satisfaction.
Okay. Learned counsel, hearing concluded. Learned counsel for the plaintiff have already filed written note of argument. For the defendant, there was time to file written note of argument.
But we have a pending GA before your lordship, my lord, seeking for injunction. It was supposed to be listed today.
It is listed.
It is listed.
It is. My lord will kindly hear it.
That is also there.
Yes.
Lordship will give direction for affidavits. I will file subject to maintainability.
Kindly hears it also and disposes of all together.
Together?
No, not.
What you have prayed for in the what injunction you have prayed for in
But
that?
they should not be permitted to use the power of attorney.
Just opposite.
Yes, absolutely, because that has already been revoked.
But as a defendant, firstly, they cannot move for file an interview without a counterclaim.
Other than what you are arguing, other than that, there is any ground in that application.
And all these documents, these are the orders passed by the division bench, the Supreme Court, all are annexed there to Millard for and the actual state of affairs. But why?
But then I'll file an affidavit subject to maintainability.
Yes. Millard, let them do anything, Millard.
No, then again controversy. Then if you file an application for not allowing and they are asking for the interim, if today I pass an order, suppose for injunction, what will happen to that?
That application would be rendered infructuous.
That's why I'm telling. That will be infructuous.
Millard, kindly hears it, Millard. Any day.
Then it will go again.
It was never our.
Millard, it is their contention in their affidavit in opposition to my application. Just that they have said by way of an application. So, Millard, this should be dealt with along.
The question raised here is there were two power of attorneys. But up till today, Mr. Sen does not disclose before the court which power of attorney.
They cannot go behind my plaint. They cannot
He
go behind
challenged
my
before
plate.
your lordship. My lord, that is clarified in that order, in that application. My lord, only the second revocation.
How
they
can
are
the
challenging
application?
before your lordship in the entire suit.
Whatever I'm challenging,
But
I'm
we
challenging. My suit is restricted
But
to that.
kindly hears it once, my lord. If lordship finds it is not proper, my lord, kindly proceeds to give orders.
Brother, it should have been
thereafter.
placed today after my closing arguments.
If it is there, then the both applications to be disposed of together.
Yes, that is
that
that
will
is
be,
not-
otherwise it will
that-
be
that is-
embarrassed to this court also.
Lordship, and your lordship will apply
Then
mine
in
for
that
once.
case, I will use an affidavit subject to maintainability.
How soon you will file affidavit?
The subject matter is same almost.
Almost same. I think new documents are coming in, so I will have to deal with those.
Yes, solved them.
Let the press for time to file. Full stop. The defendant has filed an application being GA4.
Yes.
GA4 of 2025. Praying for
Subject to maintainability, Your
praying
Lordship.
for interim order. Learned counsel for the plaintiff prays for time to file affidavit in opposition. Opposition and also challenging the maintenance of the said application. Let affidavit in opposition be filed within a week. Within a week?
My junior will be now.
Within 2 weeks.
Yes.
Reply if any there to be filed within a week thereafter. 1 week maintainability point is kept open. Let the defendants will file and let the matter appear on then quit time date hai 12th December 12th December at time hai 3 p.m.
But can it be after 18th?
After 18th then the vacation starts 19th.
Very well.
Very.
Before my lord rises.
In the meantime, the defendants shall file their written notes of argument in connection with GA1 of 2020.
My lord, item
2022. 19th. 22. 2 hai. 21 hai.
Before my lord rises, my lord, item number 5 of today's list, my lord. I had given notice that in the event it's not taken up, we would mention it, my lord. Extension of interim order, it's expiring today.
I'm opposing the prayer. I am for this phone number 4 back, my lord. Bank is suffering in council for more than 2 years, my lord. This matter is very, let this plea be heard because my.
So I am not saying I don't want a hearing.
What is ready?
Their reply on their part is.
If both are ready, the court is ready. 1 hour is there.
My lord, reply on their part is.
Monday, my lord, keeps it Monday, my lord. Tomorrow you will not come possibly.
Sorry, tomorrow is Monday only. Monday, my lord. Let it be extended only for a limited period. That is what my.
Limited period, any day convenient to the bench, lordship keeps it.
The counsel for the plaintiff raise for extension of the interim order. Counsel for the defendant raise objection and submit that due to the injunction order, the defendant is suffering very bad. At the end, counsel for the parties, this court finds that the plaintiff is already enjoying the interim order. According, the same is extended till 10th of December 2025 or until further order, whichever is earlier. Let the matter remain in the list.
Grateful, my lord.